Hello everyone, a very good evening. Welcome to the final marathon of Is the video fine now? I think it is okay. All right. In the last few days, we have completed all the four modules. We have practiced all the questions, case studies, everything. Today, we are going to revise everything and all the acts, all the provisions, so that we can finally recall everything that we have studied in the past few days. So, today we are going to focus more on the theory. I have also included some questions for your revision. So, let us start. Like in the beginning, I told you that highest priority goes from module C and D, and then we have module B, and finally we have module A. So today we are going to start with our module D. We'll be discussing the important provisions of all the acts that are there in our BRBL syllabus. So let us begin first with our module D. First act of our module D is the Indian Contract Act of 1872. So, first, what is the meaning of a contract? Contract means when there are two people involved, there's a promisor, there's a promisee. The promisor makes a proposal to the promisee, and the promisee accepts it. So, there's an agreement, free consent between the two people, and this agreement is also enforceable by law. So, when the agreement becomes enforceable at law, then we call it a contract. So, what are the essential elements of a contract? All the agreements will be contract if it is made by free consent of all the parties. It is made by parties who are competent to contract. Free consent means both should have the complete knowledge of what they are agreeing to. If there's a price consideration, the content, quality, everything, both of them should be agreeing on the same conditions. Then parties who are competent to contract. So incompetent parties are minors and people of unsound mind. Any contract entered by or with these incompetent people is a void contract. It should be made for a lawful consideration. Lawful consideration means that anything involved in it, there should be something in return for both of them, right? So both the parties who have entered the contract, they should give something to the other party and they should get something in return. Then the agreement is set for a lawful consideration. All right? Okay. So every promise and every set of promises forming the consideration for each other. One performs their functions, the other also has to perform their responsibilities. And an agreement that is not enforceable by law is said to be void. Okay. Also, any contract which is of a social nature, that is not considered a contract, a legal contract. So if out of love I'm promising someone to do a task for them, that is not a contract. It's not a contract which is enforceable by law. So it will become a void. All right. Then the next essential quality is that it should be made with a lawful object. Whatever functions that we are going to perform, it should not be illegal, it should not be immoral, it should not be opposed to the public policy. It is lawful unless it is otherwise forbidden by the law. And when the object of the contract is not lawful, again the contract will become void. So, if let's say if someone is agreeing without having a license to sell alcohol, that is a contract which is void by the law. And finally, it should not have been declared void as expressed in the Indian Contract Act, which means that it should be formed with only competent people. So these are the considerations under a formal and a valid contract, right? So there should be proposal and acceptance, free consent, there should be intention to create a legal relationship, agreement may be oral or it can be written. If any particular act says that it should be written, then we have to follow the act. It should be for a lawful consideration, it should be for a lawful object, free and genuine consent should be there, certainty and possibility of performance, agreement not has been declared void under the law, and the people should have the capacity to contract. Okay. Then we have the different types of contracts which are defined under the contract Indian Contract Act. First, we have the contract of indemnity. So when one party promises to save the other from the loss likely to be caused to them, that loss could be either by the conduct of the promiser himself or by the conduct of any other person. So that promiser is known as the indemnifier, and the person who is being promised, who is being protected, is known as the indemnity holder or the indemnified. So the indemnifier is going to protect the indemnity holder in case of all the damages that they may be compelled to pay in any suit, all the costs that they may be compelled to pay, all the sums in a compromise. Also, the indemnity holder is entitled to sue for specific performance if they have incurred the absolute liability. All right. Then a very important provision here is the specified time for notice. If the indemnity contract says that the indemnified has to inform the indemnifier as soon as possible or immediately. So that immediately means as soon as validly possible by the person being indemnified. Okay, then there can be implied indemnity. An act is done by one person at the instance of another, right? So it will be an implied indemnity. Commencement of the liability will be there, the actual loss or damage when it is suffered by the indemnity holder. Specified notice we have already seen, there should be not unnecessary delay, and as soon as possible we should notify. Okay. Then we have the contract of guarantee. What happens in the contract of guarantee? It is to perform a promise or discharge a liability of a third person in the case of the third person's default. So whether it is a contract of guarantee or it is an indemnity, that will be decided by whatever is written in the contract. All right. So the person who gives the guarantee is called the surety, and the person in respect of whose default the guarantee is given is known as the principal debtor, and the person to whom the guarantee is given is known as the creditor. So there are three parties: principal debtor, who is the original person who needs to perform the duty, then the creditor against whom the duty is to be performed, and this person will act as the surety. That is, if the principal debtor defaults, then the surety is going to provide the function that was to be done. And then, very important point that we discussed yesterday also, there are two types of contracts which are involved here. There's an express contract between the surety and the guarantee holder, that is the creditor, that if the principal debtor default, then the surety is going to perform the duty. This is the express notice. There's also an implied contract between the surety and the principal debtor. Do remember these 2 points. What is the implied promise here? That now this surety is going to step in the shoes of the original creditor. Now they will become the creditor, and the debtor will have to pay the sum involved, whatever is the liability, to the surety now. All right, so these two separate contracts are here. One is expressed, one is implied. Then the basic principles should be complied here. Only competent people should enter into the contract of guarantee. What is the liability of the surety? It is co-extensive with that of the principal debtor, right? This means that only if the principal debtor is unable to pay the debt, then the surety takes place of the principal debtor. So the creditor cannot directly approach the surety. All right. So this is there. Then if it is a continuing guarantee, then it extends to a series of transactions, not limited to one transaction, but to many transactions. Also, the continuing guarantee can be called off by giving a notice. So the future transactions, the surety need not perform. They won't be liable to perform the future transactions. In the case of death of surety, normally when the surety dies, the guarantee ends from that date. However, it depends upon the terms of the contract and the intention of the parties. All right. Also, when we are talking about when guarantees are obtained by banks, these are continuing guarantees. And in the case of death of the surety, the guarantee would stand revoked for the future transactions. Thus, the banks they prefer to break the running accounts if it is from a borrower. Okay. If let's say the principal debtor and the creditor they make some changes, any modification in the terms of contract without the knowledge of the surety, then it discharges the surety as to the subsequent transactions after the variations have been made, the surety is not required to perform them. All right. Also, if the principal debtor is discharged from the contract between the creditor and the principal debtor, at that point, the surety will also be discharged. Okay. Then release of one co-surety does not discharge others. When there are co-sureties, more than one person is acting as the surety, a release by the creditor of one of them does not discharge the others. Also, the surety released, they do not become free from the responsibility to the other sureties. They will still be liable to their part. They will have to pay the other co-sureties in the contract. And we already discussed the implied contract between the surety and the principal debtor. Once the surety makes the payment, then they can go and ask for the payment from the principal debtor. All right. If the surety, if there is any security, doesn't matter, the surety is, they know about it or not, they will be entitled to the benefit of every security that the creditor has against the principal debtor. Okay, so these are the points related to the contract of guarantee. Then, contract of bailment. Bailment means when the bailer, who is the owner of the goods, they transfer the possession to the bailee. They deliver the possession to the bailee, they hand over to perform a specific purpose and for a particular time period. All right. So the time period for which the goods will remain with the person, the bailee, also the purpose for which it has to be used, it should be specified. And the bailee, they cannot use it for any other reason. All right. Then what are the essential features of the bailment? There must be a contract between the party, the bailer and the bailee. The delivery of goods should be there. Actual delivery when physically handed over, or constructive delivery, which is a symbolic delivery like endorsement, delivery of a bill of lading, or a railway receipt. Delivery only of possession is done, not of ownership, right? Also, the delivery involves control as well as intention that others are not going to come and claim the goods. There must be a purpose for which the goods should be used. The specific goods should be returned after the contract is over, right? So, there are certain duties on the bailer and the bailee. Bailer will have to disclose to the bailee any fault there is if in the goods, any materially, anything that would materially interfere with the use of them, right? Bailee should also take care of the goods. If any damage is caused by them, they will be liable to pay the bailer. If there's a event of mixing of the goods, if it is with the consent of the bailer, then they will be, both of them, the bailer and the bailee, will be responsible in proportion to their respective shares. If, however, the bailee, without the consent of the bailer, mix the goods with their own, then if it is to be separated, the costs will be borne by the bailee. And if any damage is caused, then they have to bear the expense of it as well. Okay, so remember the two cases: with the consent, without the consent. Right? Bailey also has the lien if they have rendered any service and they have to receive any remuneration, they can retain the goods until the bailer pays them. All right. Then there's a pledge. Pledge simply means bailment of goods, not for the performance of any activity, but to create a interest on it. So the goods are kept as security with the creditor, right? So it is going to act as a security. Relationship is between the pawner and the pawnee. If the pawner defaults in the payment of the debt, then the pawnee may bring a suit against the pawner and retain the goods that are pledged as a security, or after giving notice to the pawner, they can also sell the goods that have been pledged. Also, if the proceeds of the sale are less, then the pawner is still liable to pay the balance. So there's a personal liability. Okay. Pledge can be done with actual or without actual possession. So constructive delivery is also there. If let's say the goods are kept in a warehouse, then the warehouse keeper is going to give an acknowledgement, or the key can be given to the pawnee, or if the pawner is keeping the goods with themselves, they're keeping it on behalf of the pawnee. Also, when under certain circumstances the pledgee further pledges the movable property, the pledge will be valid only to the extent of the interest of the pledgee. It should be equal. A larger value cannot be created, right? So these are the essentials of the pledge. And the last type of contract which is defined is the contract of agency. So any person giving the rights to another party to perform acts on their behalf, that is giving the person the agency. So the term agent and principal: agent is a person employed to do any act for another. Principal is the person for whom the act is done. All right, so basically there are all the other things of the contract should be maintained. The principal and the agent should be competent to contract. There are two important rules of agencies. Like, first rule is that whatever a person can do personally can also be achieved through the agent. Obviously, there are exceptions like marriage, when the act to be performed is personal. Then the second rule is who does an act through another does it himself. This means the acts of the agent are acts of the principal if done in the lawful manner and in the due course. Okay. Now the agents can be on the basis of authority. It can be a special agent for a particular task, general agent for a class of tasks, universal agent for everything they can do on behalf of the principal. On the basis of the work performed, we can have a mercantile or commercial agent, we can have a banker, or we can have a non-mercantile agent. Then the rights and duties of the agent and principal. Actually, the duties of the agent are the rights of the principal and vice versa. So, agent will have to carry out the work undertaken as per the directions given by the principal. They will carry out the work rationally with care, skill, and diligence. They will try not to cause any loss due to misappropriation or fraud. If they're facing any difficulty, they will convey it to the principal. They will not make any undisclosed secret profit from the agency. They will not put themselves in a position where interest and the duty suffer. They also have the right to receive the remuneration, a part of the profit promised, whatever is the contract. The principal will have the duty to indemnify the agent against the consequences of all lawful acts. to indemnify the agent against the causes of the acts done in good faith, also against any injury caused by the principal's neglect. All right, so these are all the important things, all the important points of the contracts which are given in the Indian Contract Act. Now, till here, I hope everything is clear. Do you have any doubts, any queries, any questions that you want to ask? Or is everything clear? So now let us try to answer some questions. Very few questions I've included because already we have practiced all of them. So let us read the question. Based on the statutory interpretation and judicial precedents relating to indemnity under the Indian contract law, which of the statements are not legally sound? You need to select the incorrect statement. Statement A. In India, courts now generally permit the indemnity holder to demand that the indemnifier settle an absolute liability even before the former has incurred actual financial loss. The phrase immediately in the indemnity contracts means implying as urgency, but judicially interpreted to allow a reasonable time depending on the situational factors. Under the Indian contract law, the indemnification is enforceable only upon the crystallized loans as held consistently in this particular act. And if a contract of indemnity mandates prompt notice to the indemnifier, failure to adhere to the provision may disentitle the indemnity holder from recovering the loss. So, which of the following statement is incorrect? Incorrect. Option A, which talks about the enforcement of indemnity where the liability is absolute, even if not yet discharged. Right? So, this is a new decision that was taken in the Gajanan Moreshwar versus Moreshwar Madan. This was the case. So, this statement is correct. The statement B, the statement B says that immediately will mean a within reasonable time, right? Statement D is also correct. If the notice is contractually mandated, failure to comply could defeat the indemnity claim. But the statement C, that was a decision under the Osman, Jamal and Sons versus Gopal. This was a older decision, right? Now even pre-loss enforcement principle exists. So this statement, statement number C, which talks about the older decision taken in this case, it has been replaced and the newer one is there. Even pre-loss enforcement principle is there. So if the absolute liability has occurred, even before the former has incurred the actual financial loss, there also the indemnity holder will have to indemnify it. So the incorrect statement is C. All right. The indemnification is enforceable only upon the crystallized loss? No. If it is certain that the loss will occur even before the actual occurring, then also the responsibility is there. All right. Now answer this question related to guarantee. Which of the following statements are consistent with principles governing continuing guarantees and rights of sureties under the Indian law? A continuing guarantee remains enforceable against the deceased surety's estate for all liabilities incurred prior to death, unless the contract provides otherwise. Where a creditor releases the principal debtor by the way of a settlement, all co-sureties are also automatically discharged. The limitation period for enforcing a claim begins from the date of demand of the guarantor, provided the account remains unsettled. Forbearance to sue the principal after the debt becomes due operates as a statutory discharge of the surety. So we have discussed about the essential features of a contract of guarantee. Try to answer this question. Which of the following statements are correct? So the first statement says that all the liabilities incurred prior to death will still remain valid. This is true. After the death, the surety is discharged, but the guarantee remains enforceable against the deceased surety's estate for all the liabilities incurred before it. So the first statement will be correct. Second statement, which says that if one co-surety is released, the other co-sureties are automatically discharged. No, the release of one co-surety does not release the other co-sureties in the agreement. So B statement, the second statement is incorrect. Third statement, the limitation period, this is also true. The limitation period begins from the date of demand of the guarantor, right? And the fourth statement related to forbearance to sue is incorrect. Mere delay by the creditor in suing the principal debtor does not delay the surety. All right. So the correct answer will be D, 1 and 3. Only 1 and 3 statements are correct. All right. Next, based on Section 150 and the related provisions governing bailment under the Indian Contract Act, which of the following statements are legally accurate? A bailer for hire is liable for damages caused by the unknown faults in the bailed goods, even if unaware of the existence at the time of bailment. If the bailee uses the goods bailed in a way inconsistent with the conditions of bailment, the bailer is entitled to terminate the contract and claim compensation. Where the bailee, without the bailer's consent, mixes the bailed goods with his own and the mixture is inseparable, the entire mixture becomes the property of the bailee. And the fourth statement, the bailee is not liable for deterioration of the goods if he exercises the due care. So this is regarding the duties and rights of the bailer and the bailee. So which statements are correct? So the higher situation is an exception. When the goods are bailed on a hire, then it is an exception to the duties of the bailee, right? So this statement will become true. The bailer for hire is liable for the damages. Otherwise, if it is a normal situation, then the bailer should have to inform the bailee about the faults in the goods. All right. Then, second, if the bailee uses the goods in a way inconsistent, the bailer is entitled. Yes, the bailee has the responsibility to use the goods in the manner for the purpose that was given in the contract. Then, the statement C will be incorrect. Why? If the mixture is inseparable without the bailer's consent, the bailer is going to hold the entire property and they will have to pay and compensate the bailee. The bailee must compensate the bailer. All right. So where the bailee without the bailer's consent mixes the bailed goods with his own ones, the entire mixture becomes the property of the bailee. No, it will become the property of the bailer, and the bailee will also have to compensate the bailer. And fourth statement, the bailee is not liable for the deterioration if he exercises the same care. All right, so the correct answer will be 1, 2, and 4. Okay, I hope all of these points are clear. If you face any confusion, then you can ask me. Next, regarding the contract of agency, which of the following are accurate interpretations of the duties and entitlements of an agent under the Indian law? An agent who secretly purchases goods from the principal and resells them at a profit without disclosure is not liable unless the principal suffers the financial harm. An agent acting without instructions may follow customary trade practices, but he still must notify the principal if any difficulty arises. An agent's right of lien extends to the. All right. So, accordingly, the correct answer here should be option C, 2, 3, and 4. Right? 2, 3, and 4. So, the agent should act according to the contract between the agent and the principal. If they do anything inconsistent with it, then the principal is not going to indemnify the agent. All right. Now we move on to the Sale of Goods Act of 1930. So the Sale of Goods Act of 1930, it basically talks about now we are not giving the goods for any purpose, for any security, we are selling it to another person. So the contract between the buyer and the seller, movable property. Okay, so the Sale of Goods Act, it extends to the whole of India. It covers the aspects of the sale made between two parties, the buyer and the seller, the agreements that they come into. Goods, here we are talking about every kind of movable property other than actionable claims and money. So goods will include stock and shares, growing crops and grass, things that are attached to or form the part of land, but they can be severed before sale. So buyer means a person who agrees to buy the goods. Seller means the person who agrees to sell the specific goods. And this goods will also involve future goods that will be manufactured or produced by the seller after making the contract of sale. However, there is a difference between a sale and the agreement to sell. The contract of sale can be absolute or it can be conditional, right? First, try to understand this thing. In the absolute contract for sale, there are no conditions to be fulfilled by the seller or the buyer for the sale and purchase of the goods. On the conditional sale, however, the parties they agree that the sale of goods will be regarded as final only on the fulfillment of certain conditions, either before or after the conclusion of the contract of sale. Right? So it is conditional. Now, when we talk about the sale and the agreement to sale, the when the people, the buyer and the seller, they come into a contract, they decide that these goods are to be exchanged for this much money on this and this date. That is an agreement to sell. The agreement to sell will become a sale when the time elapses all the conditions are fulfilled. So the agreement to sell provides that the ownership will pass on to the buyer on a certain date and on the fulfillment of the conditions that have been agreed between the two parties. So the sale where the ownership has already passed, irrespective of whether the goods have been delivered or not, in the agreement to sell, the ownership still remains with the seller. It is yet to pass, and on the fulfillment of the conditions, the ownership will then be transferred. The risk in the goods is with the buyer in the case of sale, risk is with the seller. All right, so these are the differences between the two. Then there are the certain stipulations that have to be fulfilled. Stipulations means that the things that both the parties are agreeing to. So stipulation which is essential to the main purpose of the contract of sale is a condition. And if the condition is breached, it is violated, or it is not complied with, then the party to the agreement, they would have the right to cancel the contract. That is a condition. It is essential. On the other hand, warranty is something which is collateral to the main purpose. The breach of a warranty will give rise to claim for damages only. The parties to the contract, they cannot reject the goods. They cannot cancel the contract. So whether it is a condition or it is a warranty will be decided by the buyer and the seller. Then there are certain implied conditions and warranties. Title of the seller means the seller is the actual owner of the goods. They have the right to sell the goods. Then the sale of goods should be by description or by sample, or it can be by sample as well as by description. Again, quiet possession, this is an implied warranty that the buyer shall have and enjoy the quiet possession of the goods. Once the ownership is passed, they can check it anyways. Okay, so quiet possession means when the buyer has paid the price, all the conditions have been fulfilled, ownership has been transferred, they can use the goods as per their own wishes. No person, no third party can come and disturb their possession. Then goods should be free from any charge. This is also an implied warranty. This means the third party or any other person or the seller, they have not pledged or given the goods as security to any creditor. Then the quality or fitness of the goods. This, however, is not an implied warranty. All right, the quality or fitness of the goods should be checked by the buyer itself. So this is known as caveat emptor. All the others are implied warranties. It is understood that these things will be fulfilled by the seller, but the quality and fitness, this should be checked by the buyer before they are taking the possession of the goods. Right? Next in this we have the rights of. Right. Next, we have the rights of the unpaid seller. Unpaid seller means, according to the contract, they have not been paid by the buyer, or a part of the price has been paid and the remaining is unpaid. So, what rights do the unpaid seller have? Unpaid seller is going to have rights against the goods as well as the buyer personally. Right? So let us go through these rights that the unpaid seller has. So against the goods, where the goods are in, where the property in the goods has been passed to the buyer, the unpaid seller will have the right to create a lien. They will have the right of stoppage in transit as well as the right of resale. When the property is not passed to the buyer, the seller will have the right to withhold the delivery, create a lien, stoppage in transit, as well as resale the goods. Okay, so against the goods, they will create a line, they will create a lien, they will retain the goods. However, certain circumstances or certain events will lead to termination of the lien. The unpaid seller of the goods are going to lose the lien when they deliver the goods to a carrier or the bailee for the purpose of transmission to the buyer without reserving the right of disposal of the goods. Then, if the possession transfers, they will not have the right to create a lien when the buyer or their agent lawfully obtains the possession or by waiver of the lien. However, the lien is not lost just because the seller obtains a decree for the price of the goods. Then, the right of stoppage in transit. If the buyer becomes insolvent, the unpaid seller who has parted with the possession, they can stop the goods that are in transit. They can retain them until the payment of the price, right? So these are the rights that are available. Then he can also recover from the original buyer the damages for the loss occasioned. Let's say the goods were of a perishable nature, and by the breach of the contract, any losses have occurred, so they can recover these losses. But the buyer is not entitled to any profit which may occur on the resale. However, for this, the unpaid seller will have to give a notice to the buyer. If the unpaid seller does not give a notice, a prior notice of sale to the original buyer, then the unpaid seller is not entitled to recover the damages. On the other hand, the buyer becomes entitled to the profit on a resale. All right, so before making a resale, it is important that the unpaid seller they give a prior notice of the sale to the original buyer. All right. Now, let us try to answer some questions on the Indian on the Sale of Goods Act. So, which of the following statements are valid under the Indian Sale of Goods Act 1930 regarding the nature, form, and enforceability of the contracts of sale? An agreement to sell becomes a sale only when the property in the goods transfers on fulfillment of the stipulated conditions or at a specified future time. A written contract is mandatory for the sale of goods in all cases. In a barter transaction where the goods are exchanged for goods, the provision of the Sales of Goods Act do not apply. And the fourth statement, a buyer acquires valid title to the goods even if the seller's title was voidable due to coercion. This means free consent was not there. So, which of the following statements are correct about the nature of a contract? So, statement 1 is true. The first statement is correct because it will remain an agreement to sell until the stipulated conditions are fulfilled and the transfer in the property is done. B is, however, incorrect. The agreement can be oral, it can be written, or it can be implied conditions, otherwise given in any other act. The option C is also correct. Consideration should always be in money. Goods and goods cannot be exchanged. And fourth statement is also correct because if a buyer in good faith acquires the good title and if the seller's original contract was voidable, still they are not going to lose their right. All right, so the correct answer will be D, 1, 3, and 4. 1, 3, and 4. Okay. Next question. With reference to the Sale of Goods Act, which of the following statements are legally valid? Which of the following statements are legally valid? A stipulation labeled as a warranty by the parties may still be treated as a condition if it forms the foundation of the contract. Where the buyer has accepted the goods, a breach of condition by the seller can only be treated as a breach of warranty unless there's an explicit or implied contrary term. A breach of warranty entitles the buyer to reject the goods and repudiate the contract. Parties may expressly exclude implied warranties in the contract of sale unless doing so would violate the public policy. So we have already studied the difference between the condition and warranty in a contract. So which of the following statements will be correct? So, as we studied, whether a stipulation is a condition or a warranty, it will depend on the contract between the agreement of the buyer and the seller. All right, so first statement will be correct. Second statement is also correct. If the buyer they accept the goods, we had discussed this yesterday, when the buyer they accept the goods even though there was a delay in the delivery, then they cannot sue for the breach of condition. They can only, this will be treated as a breach of warranty and they can only claim the damages. They cannot repudiate the contract. Statement C, however, will be incorrect. A breach of warranty does not entitle the buyer to reject the goods. Only a breach of condition is going to give the right to cancel the contract. And the parties may expressly include employed warranties, correct. If both the buyer and the seller they agree to exclude any implied warranty, they can do that. So the contract can be made as per the agreement between the parties. So the correct answer will be, apart from 3, all the other statements are true. So 1, 2, and 4 will be correct. Okay. Next, based on the statutory provisions and commercial principles relating to the unpaid sellers under the law, which of the following statements are legally accurate? A seller who has made part delivery of goods may exercise lien on the remaining goods. So they have not delivered all the goods, a part of it remains with them. It indicates, unless the circumstance indicate an intention to waive the right. If a check was received as consideration is dishonored, the seller is no longer deemed as an unpaid seller. The unpaid seller retains the right of stoppage in transit even if property in the goods has passed and the possession has been parted with. A seller in possession of the goods as a bailee for the buyer cannot exercise the lien over the goods under any circumstance. So again, we have just discussed the rights of the unpaid seller, the rights that an unpaid seller has. So, do they have the right to lien? Yes. Even if part delivery is done, it does not extinguish the right of lien. So the remaining goods can be retained. Second statement, however, is incorrect. If the check is presented as consideration and it is dishonored, then also the seller will be treated as an unpaid seller and they will have the rights against the goods as well as the buyer. Third statement is correct. The right of stoppage in transit is available when the property is passed, but it is found that the buyer has become insolvent. And the fourth statement will be incorrect because the lien may still be exercised if the seller holds the goods as bailee or the agent, unless he has given up that right. Alright, so the seller in possession of the goods as a bailee can exercise lien over the goods under any circumstance. So the correct answer is C, 1 and 3 only. 1 and 3 only. Alright. Based on the provisions of the Sale of Goods Act, which of the following statements are legally correct? A seller loses his lien over the goods once they're handled to a bailee for delivery, unless the right of disposal is expressly reserved. This we have just said. This will lead to stoppage of the lien, the termination of the lien. So first statement is correct. The right to stoppage in transit can be exercised even after the goods have been delivered to the buyer's agent. This is incorrect. If the buyer or their agent lawfully accept the goods, then the right of stoppage of transit cannot be exercised. So this statement is incorrect. Third one, if the unpaid seller resells the goods after giving notice and earns a profit, the buyer is entitled to claim the profit that is made. Again, this is incorrect because the notice was given. If the notice was not given and then the resale was done, then the buyer may claim the profit and the seller cannot claim the damages. And the fourth statement is true. Even without prior notice to the defaulting buyer, the new buyer under resale obtains the correct title to it. So the correct answer will be B, 1 and 4 only. The second and third statements are incorrect. Okay. Now let us move on to the Partnership Act. We have completed the Indian Contract Act and the Sale of Goods Act. Now Partnership Act. Partnership Act of 1932, it lays down the principles relating to the partnership contracts when a firm which is owned by the partners, right? It is a relation between persons who have agreed to share the profits of a business carried out by all or any of them or any person acting on their behalf. So the persons, they are known as partners and collectively they are known as a firm. So partnership is not a separate legal entity like a company. And the relations under the partnership arise from the contract, not from the status. So a Burmese Buddhist husband and wife carrying on a business or a Hindu undivided family carrying on a business, this will not be treated as a partnership. All right. Other things, there should be agreement between two or more persons, at least two persons. Maximum number of persons that can form a partnership will be determined by the Companies Act. Right now, the central government, this power has been given to central government. They have given the maximum limit within 100. If the number of partners exceed 100, the partnership becomes an illegal association, and if it goes below 2, then also it ceases to be a partnership. Then there should be an agreement, it should be for earning a profit, there should be mutual agency. Partnerships can be of three types. There can be a partnership at will for a fixed period or a particular partnership. Partnership at will means any particular purpose or time period is not given. It will continue as long as any partner gives a notice to all the other partners with their intention to dissolve. Partnership for a fixed period means for a particular time period. When the time period comes to an end, the partnership will also end, and the particular partnership means for a particular job. All right, so these are the three types of partnership. Next, what are the relations of the partners regarding each other? There are general duties of a partners, duty to indemnify the loss caused by fraud. Then the contract can also specify which partner will have the limited duty, right? So the partners of a firm can decide their mutual rights and duties. They can also change them from time to time with the consent of all the partners. This can be implied, understood by the dealings between them, or it can be expressed, specifically made clear under the contract. Then the right to conduct the business. Every partner has a right to take part in the conduct of the business, but they have to do that diligently. They have mutual rights and liabilities. A partner is not entitled to receive remuneration. They are entitled to share equally the profits, where the partner is also entitled to share on the capital. Such interest is to be paid only out of the profits of the firm. So these terms are there. Property of the firm, all the property originally brought into or during the course of business, this will be the property of the firm, but it should be acquired in the name. Then the profits which are earned by the partner should be shared equally. If the partner carries on a business competing with the firm, he is also bound to pay the firm all the profits that are made by him. And there are also the rights and duties. If there's a change in the partners of a firm, the mutual rights and duties of the partners in the reconstituted firm will remain the same. So the partners are changing. It will only vary the partnership, not the firm. Then the partners are also liable to the third party. So, what is their responsibility towards the third party? There are some implied authority of a partner. The act carried out by the partner must relate to the firm's normal business, right? The act must also be done on behalf of the firm. So, basically, the partner can bind the firm. The act of a partner, which is done to carry on the business, binds the firm. All right, the firm will be liable. So there are some acts which are implied authority, like if there's the partner who has been given the responsibility of buying and selling certain goods. So the purchase of stock of groceries, selling the groceries, receiving payments, settling accounts, borrowing money on behalf of the firm. These are implied. Where, however, there are certain situations where the implied authority does not exist expressly, thus this authority should be given to a partner, like submitting a dispute pertaining to the business, opening a banking account on behalf of the firm, compromise or relinquish any claim filed on behalf of the firm, withdraw a suit or proceeding, admit a liability. These things, there is no usage or custom of trade. So the implied authority of the partner does not allow them to do these actions. However, in the case of emergency, the partner has the authority to do all the acts, the firm, to protect the firm from any loss. Okay, so these are the liabilities. Then there's the concept of holding out. This means anyone who by words spoken or written or by a contract they're representing themselves or they're knowingly permitting himself to be represented to be a partner in the firm will be liable as a partner in that firm. If any third party in good faith has given credit to the firm, then that person who is representing themselves as a partner will also be equally liable. Then the partners may or may not enter into a partnership deed. If a partnership deed is entered, then the partners they may opt for registration or not of the partnership firm. Again, there's some ill effects of the non-registration, like no suit to enforce a right arising from the contract will be instituted in the court by the partner in a firm against anyone else or by a third party on the firm. So there are certain disadvantages regarding the effect of non-registration. All right, and regarding the rights of the minors, we have already discussed in detail. Basically, a minor, they cannot be under the Indian Contract Act entered into the partnership, but if they are admitted to the benefits of a partnership, then they will only be liable to their share. All right. So the minor may or may not take legal action against the partners for payment of their share of the property when they're ending their connection. When the minor attains the age of majority within 6 months of attaining majority, they will have to give a public notice whether they want to be elected as a partner or not. If they give the notice, then they'll be liable for their only share that they had. If they do not, then they will be treated as a normal partner and then they will have unlimited liability. All right. So these are all the features of a partnership firm. Now let us answer some questions. Which of the following statements accurately reflect the legal possession under the Indian Partnership Act? A partner who pays additional funds beyond the agreed capital contribution is entitled to 6% interest regardless of the firm's profit. Every partner, whether active or sleeping, retains an unconditional right to access and inspect the firm's books. No partner may introduce a fundamental change to the firm's business activity without obtaining unanimous consent of other partners. If nothing is agreed regarding the profit sharing, each partner is presumed to bear the losses in proportion to their capital contribution. So, basically, regarding the rights and liabilities of the partners, try to answer this question. Which of the following statements will be correct? So, we have clearly mentioned that every partner is going to be paid if they have subscribed to the share capital. It will be payable only out of the profits. So, the first statement is incorrect. Second statement, every partner by default has full inspection and access rights to books. Doesn't matter if they're a sleeping partner or not. So, second statement is true. Third is also correct. A unanimous consent is required for altering the nature of business. So we have studied about the memorandum of association. So similarly, if you want to make a major change, a unanimous consent is required. However, statement 4 says that in proportion to their capital contribution, they're going to get profit. No. Irrespective of the capital contribution, we are going to presume equal sharing of profits and losses. So the correct answer will be C, 2 and 3 only. 2 and 3 only. Okay. Next, which of the following statements correctly reflect the legal principles governing the constitution and nature of a partnership? A company, if empowered by its memorandum of association, may lawfully enter into a partnership under the Indian law. So, can a company become a partner in a partnership firm? A firm is a legal person under Section 4 of the Indian Partnership Act, and hence it is capable of entering into a partnership with another firm. A partnership cannot arise by operation of law or inheritance. It must result from a contract that satisfies the essentials of a valid agreement. An association of 120 persons engaged in banking business under the partnership deal is a valid partnership if registered under the Partnership Act. So, which statements are correct? A company is a separate legal entity. It is correct that they can enter into a partnership. So first statement is true. A partnership firm, however, is not entitled to become a partner in another firm. Why? Because they're not a separate legal entity. So second statement will be incorrect. Third statement, a partnership cannot arise by the law of inheritance. True. We discussed that the Hindu undivided family carrying out a family business is not a partnership. And an association of 120 persons. No. The maximum people who can be a partner in the firm is 100. So the correct answer will be 1 and 3. So both the options are given the same, but the correct answer will be B. All right, 1 and 3 are the correct statements. Next, which of the following statements are legally accurate in the absence of a contract, agreement, or custom? A partner in a trading firm may borrow funds in the firm's name or pledge its goods as part of his implied authority. Opening a bank account in the name of the firm by a partner without prior consent falls within the scope of implied authority. A partner cannot bind the firm by admitting liability in pending litigation unless expressly empowered. For an act to bind the firm, it must be performed in the firm's name or in a manner that reasonably conveys intent. Again, we have already discussed the rights and duties, the mutual rights and duties that the partners have. So, a partner in a trading firm can borrow funds, yes, but it should be in the firm's name. Correct. Opening a bank account without the prior consent, that is not an implied authority. So, second statement will be incorrect. Third is also true. A partner cannot bind the firm by admitting liability without the express agreement. Third statement is true. And fourth statement is also true. The partner can bind the firm to any act, but it must be performed in the firm's name and on behalf of the firm. So the correct answer is D, 1, 3, and 4 only. Without consent, the account cannot be opened by the partner in the name of the firm. This does not fall in the scope of implied authority. Okay. Under the Act, which of the following statements are legally accurate regarding the changes in the partner status? A minor admitted to the benefits of partnership becomes personally liable for the act of the firm done since such admission once he become a partner by election or passage of time. This is true. Within 6 months of attaining the majority, they have to give a notice whether they want to be elected or not. Then, if a minor elects not to become a partner, his share remains liable for the firm's act done after his notice of refusal. This will not be true, right? Then a retiring partner remains liable to the third parties for the acts done, yes, if unless a public notice is given. So after prior the retirement, all the acts done, the retiring partner will remain liable. A partner expelled in bad faith continues to be treated as a partner in the eyes of law and may challenge the validity of the expulsion. This is also true, right? The section 33 of the act requires that the expulsion should be done in good faith and as per the contract. Here the statement says it is done in bad faith. So, if those elements these are failing, the expelled partner can challenge the legitimacy. All right, so the correct answer will be C, 1, 2, and 4. All right, next. Based on the section 42 to 45 of the Act, which of the following statements are legally valid? A firm constituted for a fixed duration dissolves automatically on expiry of that term unless the partners contract otherwise. True. This is a partnership firm for a particular period. Then a court may order dissolution of the firm if one partner consistently disregards the agreements. This is also true. The estate of a deceased partner continue to be liable even after the death until a public notice is issued? No. Actually, the deceased partner is exempted from liability for the acts done after the death. Before the death, they will be liable, but after the death, they are exempted. Fourth statement, a partner is not liable for the acts done after dissolution if no public notice is given. This is also incorrect, right? A public notice is essential to escape the continuing liability unless dissolution is by death or insolvency. All right. So the correct answer is A, only 1 and 2. Only statement 1 and 2 are correct. One last question from the Partnership Act. Which of the following statements are legally valid? An unregistered firm cannot maintain a suit against a third party to enforce a contractual right, even if all partners are otherwise competent. This is true. Non-registration removes the rights to file a suit. So, statement 1 is correct. A suit by an unregistered firm for settlement of accounts post dissolution is barred. This is not true. Rights related to dissolution are explicitly excluded. So if it is dissolved, then the suit can be filed. Then the section 69 bars not only the suits but also the claims of set off arising. This is true, right? And the fourth statement, the bar on suit by an unregistered firm does not apply to the recovery proceedings. Correct. So the dissolution and recovery proceedings, these are exempted. So the correct answer is D, right? 1, 3, and 4 is correct. The second statement is incorrect. All right. That was the Partnership Act. Next, we have the Companies Act of 2013 or 1956. Okay. So what is a company? Company which is registered under the act. So unlike the partnership firm, it is important to get the company registered. It has to be compulsorily registered. It is an artificial legal person. It enjoys many rights of a natural person. However, not the Citizenship Act. Then it is an independent corporate personality. The partnership firm has no legal existence apart from the members. But in the company, it is a separate corporate personality. There is limited liability, there is perpetual succession. The incorporated company never dies unless it is wound up. It is a legal entity. So even if there's the death of members, it will not end the existence. There is separate property, transfer of shares is allowed. Common seal was important earlier, not now. Any document that requires a fixing of the common seal may now instead be signed by two directors or one company secretary and one director. And there's the corporate veil, there's the curtain, right? A separate legal entity distinct from the shareholders, but in reality, it is an association of persons who are the beneficial owners. So the court can decide to lift the corporate veil. All right. So this is also the difference between a company and a partnership. Then we have the different types of companies. Company can be a statutory company that is created under any particular law, like the nationalized banks, the Reserve Bank of India, or any other company. Or the companies can be registered under the Companies Act of 1956 or 2013. The companies can be on the basis of liability also, limited by shares, so the members will have the fixed liability as to the shares that they have subscribed to. Company can be limited by guarantee when the members they are undertaking to contribute to the assets of the company, and in the event of liquidation they will be only liable to that guarantee, not more than that. The company limited by guarantee can also have a share capital. It should be mentioned in the articles of association. And then there's the third type, company with unlimited liability. So every member will be liable without any limit. Then the company can also be a private company, a public company, government company. So if it is a private company, if the private company has a share capital, it imposes the restriction on the right to transfer shares to the number of members to 200, right? except for the one person company. The private company cannot issue a prospectus, they cannot invite public to subscribe for any shares. Public company is, which is not a private company. So the number of the members is unlimited. Seven or more persons can form a public company. All right, the shares will be listed on the stock exchange and there is no minimum paid up capital required. However, there are certain advantages that the private company has over the public company. Like the public company needs to have minimum seven members. The private company can have only two members and two directors. The public company has to have three directors. Private company need not have a certificate of commencement of business from the ROC. The public company is required to get the certificate. Similarly, statutory meetings, submitting a report, not important in the private company, but the public company has to do so. All right. Then there's the government company, which can be hold where the share paid up share capital is held by the state government, the central government, or both of them, not less than 51%. Foreign company which is incorporated under the Foreign Companies Act in the particular respective nations. They have a place of business in India. They conduct any business activity in India. One person company which has only one person as a member, but they will also have to indicate the name of the other person with their prior consent in the, let's say, event of death or incapacity of the original person who is going to act on their behalf. All right. Then a small company where the paid up share capital does not exceed 50 lakh rupees. There's also the condition on the one person company. If the paid up share capital of the OPC exceeds 50 lakh rupees, right? If it exceeds 50 lakh rupees or the, let's say, the average annual turnover exceeds 2 crore rupees immediately in the preceding three consecutive financial years, the OPC shall have to convert itself into a private company or the public company. So they can remain the OPC only if the paid up capital is less than 50 lakh or their annual turnover does not exceed 2 crore rupees. Holding and subsidiary company if the other company controls a majority composition of its board of directors or the majority of its shares. So these are the different types of companies. Then the difference between the memorandum of association and the articles of association is also important. Memorandum of association is the superior document. It is, both of them are public documents. MOA is superior. It will contain the name clause, the name that will be given to the company, right? It will contain the registered office clause, objectives clause, liability, capital clause, and the association or subscription clause. Any change that has to be made in any of these clauses cannot be done without a special resolution and ratification by the central government. Articles of association, on the other hand, is it is internal, the rules and regulations for the management of the company, right? They can be changed by a special resolution, but the ratification of government is not required. All right, so when the MOA and AOA are prepared, they are registered, it will bind the company and the members to the same extent, right? They are made public notices, anyone can go on the internet and check and read them. All right, and if a company commits an act in contravention of the memorandum, then the acts done and the liabilities arising are binding. It cannot be ratified by the company. However, anything done in contravention of the articles of association, it is only a procedural irregularity. It can be ratified by the shareholders at a general meeting. All right, and we have already discussed any memorandum of association clause can be altered only by a special resolution and with the approval of the central government. Any terms of the article of association can be altered by a special resolution. No approvals are required from the central government. Then we have the doctrines of ultra vires, constructive notice, and indoor management. Ultra vires means something which is out of the scope of the powers of the company. Intra vires means within the powers. So if the company does something ultra vires, it cannot file a suit. No one can file a suit against them. Right? So an ultra vires transaction is void ab initio. It cannot become intra vires by the reason of ratification. No company can be held liable for the obligations arising out of the ultra vires contract. All right. Then, if we talk about the constructive notice, this means that every person who is coming into a contract with the company, they are assumed to have read the memorandum and article. Also, they are assumed to have understood everything that are given in the documents. All right. It is understood that they know. So he who deals with the company is deemed to have notice of the public documents. They've also not only read them but understand them. It is somewhat a negative nature. It stops a person from contending that they had no knowledge of the contents of the public documents. Then we have the doctrine of indoor management, which protects the outsiders against the company. So, although the person who is dealing with the companies deemed to have read and understood the documents, it is not their responsibility to inquire into the regulatory practices of the company. That the company is actually regularly complying with everything that is given in the documents, in the memorandum and the articles. All right. So we can say it is an exception to the constructive notice, right? Then members of the company, a subscriber to the memorandum of the company will become a member. Membership can also be gained by allotment of shares, by transfer of shares. If the person buys shares of the company in the open market and then applies the company to register him as a member, they become a member. Transmission of shares is also there. On the death of a member, if the member has not made a nomination for the shares, then the surviving joint holder or the legal representative, they have the right to register themselves as member. Membership can also be by acquiescence, that is, if they allow their name to be put on the register. A joint membership can be there, and beneficial owner in the records of the depository. All right. So any person who is competent to contract can become a member. Minor and persons of unsound mind cannot. Company can become a member. Partnership firm cannot become a member. Registered society can become a member. Non-residents are not until they have complied with the FEMA regulations. LLP can also become a member. Insolvent person will remain a member unless their name is removed from the register, and trade union can also become a member. All right. Then the register of the members will be maintained. It will be kept at the registered office or any other place after giving a special resolution, and the ROC should be given a notice. All right. Then if we talk about the prospectus, prospectus means it is a document which is issued, and it will also include a red herring prospectus when the company is offering the public for the subscription or purchase of any securities. So the company proposing to make an offer of securities may issue a red herring prospectus prior to the issue. The red herring prospectus will not contain the complete details of the price of the securities and the quantum. The necessary things will be mentioned. Complete details will be given in the prospectus. Shelf prospectus means that if the securities are to be issued over a period of time, over certain periods, then without the issue of a further prospectus, one time the prospectus can be created and it will be kept at the shelf for future uses. Now, whenever a prospectus is created, then the time of the issue that is given, it should be only after the incorporation of the company. Contents should be correctly given. Date of publication. Prospectus must be signed by every person who is the director or proposed to be a director. Application form along with the prospectus should be given. Statements should be given in the prospectus that everything that is given here is true, and before issuing the prospectus, it must be delivered to the ROC. All right. No prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof is delivered to the registrar. If there are any misstatements, there is remedy against the company as well as the promoters and experts, civil as well as criminal liability. All right. Now let us solve some questions. Which of the following statements accurately capture distinctions between partnership firm and the companies? A partner can contract with his own partnership firm if authorized by all the other partners, whereas a shareholder may always contract with the company. Registration of a partnership is optional, but the company must be incorporated under the Companies Act. The property of a partnership firm is jointly owned by all its partners, while the property of the company is owned by the company itself as a distinct legal person. The public company may be formed by any number of persons. Private company must not have more than 100 members, including the employee shareholders. So we have discussed the difference between partnership and a company. So which of the following statements will be true? First statement is incorrect, right? A partnership cannot become a partner in another firm because it is not a separate legal entity. Then the second statement will be correct regarding the registration. Third statement is also correct. A firm is not a legal person. Property is held jointly by the partners, but company is a legal person. The property will be held in the name of the company. And the fourth statement is incorrect. Private companies may have up to 200 members, not 100. All right, partnership firms are limited to 100 persons, but not private companies. All right, so the correct answer becomes B, 2 and 3 only. 2 and 3 only. All right, let us try to answer this question now. We need to fill in the blanks. The minimum number of members required in a private company, whether it is 3, 7, 12, or 2. So the minimum number of members in the private company should be 2. In the public company, it is 7, right? The minimum numbers required in the public company is 7. Maximum number of members in the private company can be 200. Maximum number in the public company is not given. Any number of people can become the members. A private company should have a minimum capital of rupees. So what is the minimum capital requirement of a private company? Is it 5 crore, 5 lakhs, 1 crore, 1 lakh, or no minimum requirement? Again, there is no minimum requirement for the private company as well as the public company. And in a government company, the government holds at least dash percent of the paid up capital. So whether it is 12, 15, 50, or 51, so the majority is held by the government. It will be 51%. 51% of the paid up capital is held by the government, central or the state government. So these are the correct answers. Next, which of the following statements correctly distinguish the legal status and functional boundaries of the MOA and AOA? The memorandum overrides the article of association. This is true. The memorandum is laid down with the constitutional foundation, so it will always have the overriding fact. Then, any act that is done by the companies in breach of the memorandum is void and it cannot be validated. Again, true. It cannot be ratified by the unanimous shareholder consent. Okay, so first and second statement is true. Third statement, alteration of the article requires a special resolution and approval. No. Alteration of the memorandum requires approval from the central government, but any change in the articles can be done only by a special resolution. While articles govern the internal management, memorandum clauses, such as change in registered office to another state, require a special resolution and approval of the central government. This is also true. So the correct answer should be 1, 2, and 4. All right. The correct answer will be C, 1, 2, and 4. The third statement is incorrect. Okay. Which of the following statements correctly reflect the legal doctrine of constructive notice as applied to the corporate documents in India? Any person dealing with a company is legally presumed to have read and understood the company's public document, including the memorandum and articles. This is true. This is the doctrine of constructive notice. Then, the doctrine of constructive notice bars an outsider from claiming ignorance about internal resolutions. No. External knowledge is important, but internal regulation, whether the company is complying, that this is not true. So the second statement will be incorrect. Then third statement, outsiders are the person dealing with a company is deemed to be aware of the limits of authority conferred on the company officers. Again, this is correct. The outsiders are deemed to know the extent and limits of the companies and its officers. And the fourth option is that the constructive notice imposes a positive obligation. No, it is a negative manner that every person should know about the public documents, they should understand them. So the correct answer will be A, 1 and 3 only. The second and fourth statement is incorrect. All right. Okay. Next question. Under the Companies Act and the relevant judicial principles, which of the following persons are deemed members of a company even in the absence of a formal application? So, a subscriber to the memorandum at incorporation, irrespective, will be a member. A person who permits his name to be entered in the register, a nominee required as a beneficial owner, a legal hire of the deceased member who has not applied for the transmission but intends to retain the shares. So, this we have already discussed. Subscriber to the memorandum, a person who permits their name to be entered in the register, also a nominee, right? A beneficial owner is also deemed to be a member. However, mere legal hireship does not confer membership until the transmission is approved. So, the correct answer will be A, 1, 2, and 3 only. All right, the fourth statement will be incorrect. The fourth statement will be incorrect. Okay, which of the following statements are legally valid regarding the compliance requirements and liabilities related to a company's prospectus? A prospectus can be issued either before or after incorporation provided it is signed. No, a prospectus should be issued only before, right? So it is a statutory prerequisite under the act. So first statement will be incorrect. Second statement, if a person subscribes for the shares based on untrue statements, remedies are available. True, both criminal and civil. Then a prospectus becomes invalid if issued more than 90 days, again true. And the consent from an expert whose opinion is quoted in the prospectus must be in writing, and the expert must not be involved in the company's management, again. This is also true. So the correct answer will be 1 is incorrect, 2, 3, and 4. 2, 3, and 4. These statements are true. Then let us answer some more fill in the blank type questions. What is the maximum number of directors in the private company? So we discussed that the maximum number of directors minimum required is 2, maximum can be 15. The maximum number of directors in the public company can also be 15. The minimum number of directors that are required in the public company. This was the advantage that the private company has over the public company. The public company requires minimum 3 directors, and the private company requires minimum 2 directors. Then at least dash of the total number of directors of a public company are to be persons whose period of office is liable to determination by the retirement by rotation. So this is options are given 2, 3, 7, or two-thirds of the total number of members. So actually at least two-third should be liable by retirement by the rotation. Then every public company or a private company which is a subsidiary of the public company having a paid up share capital of rupees dash must have a managing or whole time director. So every public or private company, what is the paid up share capital of rupees? If that is there, they must have a managing or whole time member acting as the director. So whether it is 5 crore, 5 lakh, 1 crore, 1 lakh, or there is no such requirement. So trick question, actually there is no such requirement. Then the additional directors are appointed by the board of directors, promoters, underwriters, or the shareholders. So the additional directors are appointed by the board of directors. Alternate directors are also appointed by the board of directors. Casual vacancies in the board of directors, if any, will also be fulfilled by the board of directors. So the correct answer here in all of these cases will be the board of directors. All right, here are the correct answers. Next, we have the provisions of the Limited Liability Partnership Act of 2008. Now, we have discussed about the partnership firms, we have discussed about the company. Somewhere in between, there are the limited liability partnerships. All right. So, these are also body corporates. It means a company which is defined in the Companies Act, right? There will be a designated partner in the limited liability partnership. So any agreement between the partners of the LLP that they are going to share a limited liability. They will not have unlimited liability towards the debt. All right. So it is a body corporate. It is incorporated under the LLP Act, and it is a separate legal entity from its partners. LLP will have perpetual succession, and any change in the partners of the LLP will not affect the existence, rights, or liabilities of the LLP. Then LLP should have the designated partners. What are the designated partners? Any person can be capable if he has not found to be unsound mind, or if he is, let's say, an undischarged insolvent, then they will not be eligible. Or LLP, every LLP must have at least 2 partners. Then if at any time the number of partners it is below 2, and the LLP carries on the business for more than 6 months. So if the number is reduced, only one person is carrying out the functions of the LLP for more than 6 months, then the person who is now the only partner of the LLP during that time, he will be liable after those 6 months. So for 6 months he can continue, but after those 6 months he will be personally and completely liable for all the obligations. So remember this time period of 6 months. All right. Apart from this, every LLP shall also have at least two designated partners, and one of them should be a resident of India. Then the designated partners, what will be their responsibility? They will be responsible for doing all of the acts which are given in the Partnership Act. So, filing of any document, filing of any return, any statement, or any report. Also, they will be liable to all the penalties if they contravene any of the provisions of the LLP Act or whatever is there in the partnership agreement. They will be responsible to perform those functions. They will be liable to the penalties if they contravene. Then LLP has to be incorporated under the LLP Act, two or more persons for a lawful business with a view to share the profit. Their names should be there in the incorporation document. It will be filed in the manner and with the fees as prescribed with the registrar. Along with the incorporation document, a statement should be there that would be made by the any advocate or a company secretary or a chartered accountant or a cost accountant who is also engaged in the formation of the LLP. All right. So, this is regarding the incorporation, regarding the registration. We said the registrar will shall retain the incorporation document, right? Registered office will be mentioned in the document. Every LLP is required to have the registered office to which all the communications and notices must be sent. A document may be served on the LLP or the designated partner by post or any other matter to the registered office. All right. So, what is the effect of registration? The LLP by its name may be capable of suing as well as being sued. They will also be capable of acquiring, owning, holding, developing, or disposing of property, immovable or movable. They can also have a common seal if they decide to have one, and doing and suffering such acts that the body corporates are allowed to do. All right. Then regarding the partners, as soon as the LLP is incorporated, all the partners, all the persons who have subscribed their name, they will become a partner. Relationship of the partner, the mutual rights and duties will be determined by the agreement between them. All right. So the liability that they're going to own, that will be very specifically given. Then cessation of the partnership. Any person may cease to be a partner in accordance with an agreement, or if there's no agreement, then by giving a notice to not less than 30 days, right, to all the other partners. They will also cease to become a partner on their death or dissolution of the LLP itself. If the partner is declared to be of unsound mind by the competent court, or if he has applied to be adjudged as an insolvent, or they have been declared as an insolvent. So when the person has ceased to be a partner in the LLP, they will be regarded as the formal partner, right? But again, they have to give a notice to that, and they will be liable for the previous acts that they have done. All right. Then a partnership firm can be made by conversion also. So, conversion from a firm to the LLP, a partnership firm can be converted into the LLP, or a private company can also be converted into the LLP, or a unlisted public company can also be converted into the LLP. All right, so what will be the effect of this conversion? The registrar, when they're satisfied that a firm, a private company, or the unlisted public company, they have complied with the provisions of these schedules, the second, third, or fourth schedule, then they will accept their application and they will convert them. All right, upon the conversion, the partners of the firms, the shareholders of the private company or the unlisted public company, their duties and rights will be changed. They will be bound by the provisions of the respective schedules. Right? So these are the things that will be followed in the LLP. Now, some questions that we can answer from the LLP Act. Based on the section 24 of the LLP Act, which of the following statements are legally valid in the context of cessation of the partnership? A person ceasing to be a partner in an LLP continues to be regarded as a partner by the third parties unless a public notice is delivered. This is true. Like we said, a public notice has to be given. So, correct. Second, in the absence of a partnership agreement, a partner may resign by giving at least 30 days notice. This is also true, right? The resignation is allowed, but 30 days notice to all the other partners has to be given. Once a partner resigns, he is automatically discharged from all the liabilities, even without express intimation or indemnification. This is, however, incorrect. The former partner, whatever acts that they had done before they cease to be a partner, they still will be liable. They will continue to be liable for them. All right. So he will not be automatically discharged from all the liabilities incurred during his time as a partner. Right? So the third statement will be incorrect. And the legal heirs of the deceased partners are entitled to claim the capital contributed unless excluded. Again, this is true. All right, so the correct answer should be 1, 3, and 1, 2, and 4. All right, the third statement is incorrect. They will be liable up to the formal cessation. Then, again, which of the following statements are legally accurate regarding the conversion of a firm or a company into an LLP? A company or firm is considered legally dissolved and removed from the official records immediately upon issuance of the LLP registration certificate. This is true. Once the registrar is satisfied that all the terms and conditions have been complied with, this will be followed. Then the tangible and intangible assets will be automatically transferred to the LLP. Again, true. Then third statement, post conversion, it is mandatory to inform the registrar within 90 days. No, it is mandatory to inform the old registrar within 15 days, not 30 days or 90 days, it is 15 days. And the fourth statement, the LLP created through conversion becomes a separate legal entity only once the former entity is voluntarily wound up. It is not dependent on the separate winding up. The LLP becomes a separate legal entity from the date of registration itself. So the correct answer, only 1 and 2 are correct. 3 and 4 are incorrect. All right. Which of the following statements is not legally accurate according to the LLP Act? You need to find out the incorrect statement. So the central government may prescribe specific accounting and auditing standards for the classes of LLPs in consultation with the National Financial Reporting Authority. Yes, this power has been given to the central government. Every LLP is required to file its annual return with the registrar within 30 days of the close of financial year. No, from the end of the financial year, not within 30 days, but within 60 days, the returns have to be filed. The annual return has to be filed within 60 days. Then a statement of account and solvency must be filed annually and may attract penalties. This is also true. LLP may, if the LLP fails to file the annual return, penalties can be imposed. So the correct answer will be B. This is the only incorrect statement. All the others are true. So the default in the annual filing draws a penalty. This is the penalty that can be imposed. 1 lakh rupees maximum. and on the designated partners as well, because who are responsible to file the annual return? The designated partners. So if they fail to make the returns or any documents within the stipulated timeline, 50,000 max will be the penalty imposed on them. All right, so we are done with this act as well. Next, we have the Transfer of Property Act. So, Transfer of Property Act basically deals with the mortgage of the immovable property. All right. So, mortgage is what? It is a transfer of interest in the specific immovable property to secure the payment of money given by the way of loan or any pecuniary liability. The transferor is called the mortgager. The transferee is called the mortgagee. Mortgage money includes both principal and interest, and the instrument by which the transfer is effected is known as the mortgage deed. All right. Then we have certain types of mortgages, their characteristics are important. First, a simple mortgage, where without delivering possession of the mortgage property, the mortgager binds himself personally to pay the mortgage money. And if in the case of default, the mortgagee will have the right to cause the mortgage property to be sold. All right. The proceeds will be used only up to the amount of the credit. Remaining will be returned to the mortgager. Also, if the proceeds fall short of the mortgage money, then also they have the right to claim the money from the mortgager. All right, so the mortgager does not deliver possession, binds himself personally. On the event of failing, on the decree of the court, the mortgagee will have the right to sell the property and recover the dues. Mortgage can also be done by the conditional sale, where there's a sale but ostensible. So, when the default occurs, the sale will become absolute. Payment is done, sale will become void. When the payment is done, buyer will transfer the property back to the seller. Mortgagee will transfer the property back to the mortgager. All right. So this is the conditional sale. Usufructuary mortgage. In the other types of mortgages, the mortgagee has no right over the rent or profits that are arising from the mortgage property. But in the usufructuary mortgage, the mortgager delivers possession expressly or by implication. And what happens here? The mortgagee will have the right to receive the rents and profits accruing from the property, and it will be used to the payment of interest or the principal, whatever they decide. So the mortgager delivers possession. The mortgager authorizes the mortgagee to retain the possession until the payment is done, also to receive the rents and profits, and appropriate it for the payment of interest. However, it is not preferred by the bankers. Why? Because it can take a very long time to recover the debt from the rent and profit. Then we have the English mortgager. In the English mortgage, the mortgager binds to repay the mortgage money on a certain date, and transfers the mortgage property absolutely to the mortgagee. So here, this is not an ostensible sale like in the conditional mortgage, it is an absolute sale. But provision that the mortgagee will retransfer it upon the payment of the money. All right. Then we have the most important type of mortgage, which is the equitable mortgage or mortgage by the deposit of title deeds. So, in the towns notified by the state government, Calcutta, Madras, Bombay, where the mortgage is created, the document is signed. Property can be located anywhere in India. All right. So rather than delivering possession, we are keeping the title deeds, the ownership deeds. It can be actual, it can be constructive, but copies will not be accepted unless in exceptional situations. So this is the equitable mortgage. And last type of mortgage is the anomalous mortgage, which is negatively defined. Any mortgage which is a combination of the above type, it is an anomalous mortgage. All right. So then there are provisions to sell the property that has been mortgaged by obtaining a court decree. even without court intervention like SARFAESI Act, and the enforcement of mortgages through court requires the court will make a preliminary decree and then it will make a final decree. So two types of decrees are there. Then leases of immovable property can also be done. All right, and actionable claims are also there. Actionable claim mean a claim to any debt that is other than a mortgage, hypothecation, or a pledge. All right, so actionable claims can also be transferred with or without consideration, can be done only by the execution of the instrument in writing by the transferor. However, there is no mandatory requirement of giving notice to the debtor before the transfer is done by the mortgagee. All right, so let us answer some questions. So, which of the following statements are legally accurate regarding the simple mortgage and mortgage by the conditional sale? In a simple mortgage, the mortgager is personally liable for the repayment and retains the possession. The mortgage by conditional sale becomes valid only if the conditional clause is recorded in the same document that affects or purports to the effect of the sale. The mortgage by conditional sale necessarily requires transfer of possession to the mortgagee at the time of the mortgage. In a simple mortgage, the mortgagee may directly sell the property without the intervention of the court. I'm waiting for your answers. This is a very simple question and you can answer it. So, which of these following statements will be correct for the simple mortgage and conditional mortgage? First statement is true. Without delivering possession, personally liable the mortgager becomes. Mortgage by conditional sale, it should be mentioned in the same document as the sale deed, right? Correct. The correct answer will be A, 1 and 2 only. All right. Next, the other two statements are incorrect. We already know. Next, under the Transfer of Property Act, which of the following statements are legally valid in the context of a mortgagee's power of sale without court intervention? A mortgagee can exercise the power of sale without court intervention only where such power is expressly conferred in the mortgage deed and the mortgagee is the government, or the property lies in a specified notified town. The English mortgage can exercise power of sale without court intervention irrespective of religion or ethnicity of the mortgager or mortgagee. Sale without court order must be preceded by a written notice demanding the principal repayment with at least 3 months default thereafter. Once a property is sold professedly under the power of sale, the purchaser's title is valid even if the procedural irregularities occur during the sale, but the aggrieved party may claim damages. Quite lengthy statements are here, but if you read them carefully, you can definitely answer it. So the first statement is correct. The act it provides two scenarios for the out of court sale. When the government is the mortgagee or the property is located in the specified town and the deed expressly permits it. All right, statement 1 is true. Statement 2, however, says that the religion or ethnicity of the mortgager or the mortgagee does not matter. But in the case of English mortgage, religious or tribal classifications do matter. If either party belongs to a protected category, then the power cannot be exercised without the court order. All right. So, second statement is incorrect. Third statement is true. Without a prior notice, the enforcement cannot be done. And the fourth statement is also true. A bona fide purchaser's title is protected even if the power of sale was improperly exercised. So, even if the mortgagee is selling the property not complying with the provisions, then the buyer will not be liable. The buyer will be protected. All right. So the correct answer will be D, 1, 3, and 4. All right. Next, we have the Right to Information Act. Right to Information Act basically means the citizens, they can seek information from the public sector, even the public sector banks, the particulars of the organization's functions, duties, procedure followed in the decision making process, norms set by it for the discharge of its functions, rules, regulations, instructions, manuals, and records that are held by it. All right. Although the RTI also provides for the exemption from the disclosure of certain information, like commercial judgment or anything that would harm the integrity and the anything of the nation, right? So that information is exempted. All right. So also it says that every public authority would maintain all the records that are duly catalogued in a manner that if information is sought, then in a reliable way, in a reasonable time, it can be provided. Also, they have to publish the particulars of the organization, powers and duties, rules and regulations, the monthly remuneration, directory of officers, particulars of the recipients of concessions. All of these things they automatically have to publish. All right. There are also certain terms which are defined, like appropriate government can be the central government or the state government. There's also the Central Information Commission formed by the central government, or State Information Commission formed by the state government, central or state public information commission officer that are appointed. Now, what is the procedure for obtaining information? The public information officers who are designated by the public authorities and all the administrative units, they are required to provide information to the citizens that request for the information under the act. This is the duty of the PIOs. So the PIOs will deal with the request from the persons who are seeking information when the request is made in writing. If, however, the information requested is closely related with the function of another public authority, then within 5 days they will have to transfer the request to the other public authority and inform the applicant. PIO can also seek assistance of any other officer for the proper discharge of their duties as soon as possible, but maximum within 30 days. They have to provide the information. If the information concerns the life or liberty of a person, then within 48 hours of the receipt of the request, the information has to be provided. If the PIO fails to give a decision within the period specified, it will be deemed that they have rejected the request. But they have to provide the reasons for the rejection, the period within which they can make an appeal against the rejection, also the particulars of the appellate authority to which they can file the application. Also, when they're providing only partial access, only part of the information is provided, again, the reason for that decision, the name and designation of the person who is giving the decision, right to appeal. All right. What else is there? We have already seen there's the Central Information Commission and the State Information Commission who are going to deal with the disputes. Third party information within 5 days, it has to be taken. Information that is exempt from disclosure that would affect the sovereignty and integrity of India, the security or any scientific or economic interests of the state or foreign state. Information which has been forbidden to be published by the court. However, information that is allowed to be given to the parliament cannot be rejected. All right. Then if we talk about the appeal, if the information is rejected, misleading information is given, or partial information is given, basically the applicant is not satisfied by the decision that is taken by the PIO. So the Central Information Commission and the State Information Commission will be formed, right? But first appeal will be made to the higher PIO. Any person who does not receive the decision within the specified time period or is aggrieved by the decision with the Central Public Information Officer, then within 30 days they can make an appeal to an officer who is in a senior rank to the Central Public Information Officer. So there are two types of appeal. First appeal to the senior officer, senior to the central PIO, and if they are aggrieved by the decision given by the central, this senior officer, then they can make the appeal to the appellate authority, that is the Central Information Commission or the State Information Commission. Both of the appeals, Central Information Commission or the State Information Commission, within 30 days from the days when they receive the decision from the PIO. All right. So, where can I make an appeal? If, let's say, the Central Public Information Officer has failed to give me any reason for the rejection, they have not furnished the information within the time specified 30 days or 48 hours, they have denied the request for the information just to hide it, they're protecting some other person, they have given incorrect information or misleading information, they have destroyed information or obstructed in furnishing the information, I can make an appeal. All right. So let us answer some questions. Which of the following statements is not legally correct as per the Right to Information Act and the related rules? If the Central Public Information Officer notifies the application of a fee payable, the time between the dispatch of that intimation and the actual payment is excluded when computing the 30 days response. Is this true or not? This is true. Then statement B says disclosure of third party confidential information is absolutely prohibited. No. In general cases, it can be rejected, but if the disclosure, if the disclosure is in interest of the public and it outweighs the possible harm, then the information can be provided. Let's say keeping the information secret would cause harm or damage to the public. Then it is important that the information is provided. All right, and we need to mark the incorrect statement. So, B. The CPIO must notify the third parties within 5 days if it involves a third party. True. A CPIO may reject a request to for access of information if it would infringe the copyright owned by someone other than the state. Again, this is true. So, the correct answer will be B. This is the only incorrect statement. All right. Which of the following statements are legally accurate? A person who believes that their application was not accepted by the Central Public Information Officer, they can make a direct complaint with the Central Information Commission. This is actually an exception. We studied that first we need to make an appeal to a senior officer of the CPIO. But this is when the information was hidden or the information was rejected. If they have the right to believe that their information was not even accepted, it was not even considered, then they can directly go to the Central or the State Information Commission. All right, so do not get confused. This statement is true. Second, the individual must file the first appeal within 90 days. No, they have to file the first appeal within 30 days. Then a second appeal lies before the Information Commission will be filed within 90 days. Okay, it should be first appeal lies before the CIC and SIC within 30 days. Second appeal also 30 days, but it can be extended to 90 days. So, okay, this is true. Where the information concerns third party confidentiality, the third party has a right to appeal within 30 days. So, yes. All right. So, the correct answer will be D 1, 3, and 4. Okay. What else? Which of the following statements correctly outline the obligations and operational scope of a public information officer? A PIO is required to assist applications who are unable to make written one true. They will accept only the written applications. Where the people cannot make written application, they will give reasonable assistance to people who can't write. Then if the requested information pertains more closely to another public authority within 5 days, it should be transferred. Again, this is true. In all the cases, the PIO must provide the requested information within 30 days. No. If it relates to the life and liberty of the applicant, then within 48 hours of the receipt of the application, the information has to be provided. In case where the information sought concerns life or liberty of a person within 48 hours, again, this is true. So the correct answer is 1, 2, and 4. Okay. Next, we have the Right to Information Act, which basically talks about the electronic governance, right? So, electronic governance, legal recognition to the electronic records and electronic signatures, including the government and its agencies, right? So information or any other matter shall be in writing or in typewritten form, or it can be in the printed form. Okay, so this is electronic governance. Then certain terms, who is the appellate tribunal under the Information Technology Act? It is the Telecom Disputes Settlement and Appellate Tribunal. Electronic government governance give legal recognition to electronic records, electronic signals, also delivery of services by service providers. Then, if we are talking about the certifying authorities, then the Act envisages a controller of certifying authorities. This controller will perform the function of exercising supervision over the certifying authorities. Certifying authorities basically who are going to certify whether this digital signature is valid or not. They will give the digital signatures to the entities. So they will exercise supervision, certify the public keys of the certifying authorities, lay down the standards and procedures to be mandated. Then what else? If any person tries to access the computer or computer system and that person is not authorized, if they're trying to extract any data, again using any unlawful method, or introduce or cause any harm, damage any computer system, disputes that disrupts or causes disruption, they will be liable to penalty. There's also the right to appeal to the telecom disputes and settlement appellate. Okay, however, no appeal shall lie to the appellate tribunal from an order made by the adjudicating officer with the consent of the parties. If we talk about the investigation, who is going to conduct the investigation, that there has been a contravention of the Information Technology Act, it will be investigated by a police officer not below the rank of inspector of police. All right. Then the critical information infrastructure means a protected system. The act also applies to the electronic check and truncated check. Okay. So again, questions related to the Information Technology Act. Which of the following are legally accurate responsibilities and provisions related to the controller of certifying authorities and their digital signature oversight? The controller is empowered to prescribe the form content and operational requirements of the digital signature certificates that are issued. Correct? This is a power given to the controller. Certifying authorities must seek prior permission from the controller before appointing any auditors. This is also true. The controller may facilitate establishment and oversight again by multiple certifying authorities. The duties of the subscribers with respect to the digital signatures are governed entirely by the controller. This is not true. The controller does not have the unilateral power to revoke the access by taking the decision on their own discretion. There will be a regulatory procedure that has to be followed. So 1, 2, and 3 is correct, but fourth is not a power that is given to the controller. Then, which of the following statement is not legally accurate? The provisions of the IT Act extends to electronic checks and truncated checks subject to amendments that are made in the Reserve Bank of India Act. Okay, this is true. Once notified, the changes introduced become permanent and are not subject to parliamentary oversight. This is not true. If the government wants to make any amendment, they can give a notification. It will be placed in both the houses of the parliament. It can be passed with modifications or it can be rejected. So this is not true. Third statement, electronic check, truncated check have the same meaning as the Negotiable Instruments Act. True. There's also the Cyber Regulation Advisory Committee, which will play an advisory role in the rule making and policy direction. This is also true. So we need to pick out the incorrect statement. The incorrect statement is B. Okay. Last act of the module D, the Prevention of Corruption Act. Basically, to combat corruption and other misconducts, mainly in the government and public enterprises. So, this act allows or gives powers to the central and state governments to appoint the special judges. If any public servant commits any conduct of criminal misconduct, dishonestly or fraudulently misappropriates, enriches himself illicitly during the period of his office, they are said to be involved in corruption. All right. So, special judges will be appointed by the state and central government. Cases that will be tried by them. Every offense shall be tried by the special judge for the area for which they have been committed. Suits can also be transferred, not to the High Court. One suit can be transferred to another special court. From one special judge to another special judge, from one special court to another special court, but not to the High Court. Then the offenses and the penalties we have already discussed, like where the public servant is being bribed, punishment for a term not less than 3 years, also a fine. If they're taking undue advantage, same 3 years fine. So all of these terms are there. Okay, so here's a scenario that is given to you. Do we need to revise all of the sections? No, that is not important. Fixing of fine will depend upon the court will take into consideration the amount or value of the property that the accused person has obtained under corruption. Persons who are authorized to investigate, this also we have already discussed. If it is a case of the Delhi Special Police Establishment, then an inspector of police in the metropolitan areas of Bombay, Calcutta, Madras, and Ahmedabad, or any other specified metropolitan area, then the assistant commissioner of police anywhere else, the deputy superintendent of police, or a police officer of the equivalent rank. They will conduct the inquiry and they will recommend the order. All right. There's also the right to appeal and revision. The act here, whatever decision is taken by the special judge, the appeal and revision normally lies with the High Court. Okay. So let's try to answer this scenario. A senior public servant is alleged to have misappropriated public property entrusted to him. An audit reveals multiple cash inflows into his personal account over several years, grossly disproportionate to his known sources of income. During trial, he argues that the financial transactions were legitimate gifts from the distant relatives. No satisfactory documentation is, however, provided. Separately, an executive of a private company is found to have promised 50 lakhs to the servant's personal aid, facilitating clearances. So, what will be the legal position? Try to answer this scenario. All of the offenses committed by the public servant is given. What will be the penalty imposed on them? So, what will be true? Actually, tell me how many of the statements will be true. More than one are correct here. So, which statements will be true? Will statement A be correct? Yes, because for they are illicitly enriching themselves. Also, they are unable to prove the riches that they're getting. So, A is true. Then, commercial organization bribery is also there. This private company has promised 50 lakh rupees to the public authority. So, this is also true. Since the promise of 50 lakhs was made to a personal aid and not to the public servant, no. It says although the public authority's servant was paid, not the public authority itself. No offense under the PC Act can be made out. This is incorrect because the public servant is going to act on behalf of the officer. And the fourth statement says the trial court may invoke section 15 if there's a proven attempt to convert entrusted public property even if no final misappropriation occurred. Actually, the section 15 of the PC Act, it says it deals with the punishment for attempting to commit an offense. It will also be punishable with imprisonment, again, not less than 2 years, can be extended to 5 years, and a fine. So, doesn't matter if the misappropriation happens or not. Even when they're attempting to commit an offense, it will be treated as an offense, and yes, the trial court will make a decision. So, the correct answer is A and B. We are done with module D. Till here, everything is clear. All the acts that would we have discussed in the module D. Any doubts, any queries, or any questions? Or is everything clear? Please confirm. All right, so let us start with the acts that are there in our module C. First, we have the Reserve Bank of India Integrated Ombudsman Scheme, which has integrated, merged all the previous acts, ombudsman schemes that were there. The Banking Ombudsman Scheme of 2006, the Ombudsman Scheme for the NBFCs 2018, and the Ombudsman Scheme for the Digital Transaction 2019. So, any person who faces a deficiency of service from the commercial banks, RRBs, scheduled primary urban cooperatives, NBFCs, payment systems, even the credit information companies. First, they will make an application to the regulated entity. If they do not get a satisfactory response, then within 30 days, if they do not get the response, they can make an appeal to the ombudsman. Appellate authority is going to mean the executive director in charge of the department of the Reserve Bank. We have the secretariat, representative, authorized representative if the any person other than an advocate who is appointed and authorized in writing to represent the complainant in the proceedings before the ombudsman, that is the authorized representative. Okay, deficiency in service means a shortcoming or inadequacy in financial service. This will, however, not mean any dispute between a vendor and the regulated entity, any dispute between two regulated entities, any internal mismanagement. That is not there. All right. Then what else? We have the ombudsman. The Reserve Bank will appoint the ombudsman. The Reserve Bank will establish the CRPC and appoint the officers. Cost will be borne by the Reserve Bank of India. What is the procedure of redressal? We have already discussed. We'll wait for 30 days after making a complaint to the regulated entity, and then we will file it to the ombudsman. All right. What else? Grievances which are not maintainable, commercial judgment, disputes, grievances not addressed directly to the ombudsman against the management. Action is already initiated by the regulated entity. These will not be taken by the ombudsman. All right. So when an application is received by the ombudsman, what will the ombudsman do? They will send a notice to the regulated entity to furnish certain information and documents. If the documents are furnished, then they will start with the scrutiny. If not, they will give ex parte decision. In the case of the ex parte decision, now the regulated entity loses their right to make a further appeal to the appellate authority. All right. Okay. Then what else? These things are there. All right. Now let us answer some questions from the integrated ombudsman scheme. Which of the following statements correctly reflect the procedural features of a complaint? So, the Ombudsman is required to conduct proceedings bound strictly by the Indian Evidence Act unless both the parties agree. Failure of a regulated entity to respond will result in the ex parte decision. A complaint is deemed resolved only if a signed settlement agreement is submitted by both the parties. The ombudsman is empowered to infer absence of relevant information as failure to furnish the documents. Written versions of the complaint must be submitted within 15 days with no provision from extension. So, first statement is incorrect. The ombudsman need not follow Indian Evidence Act. They will follow the law of principle, equity, fair treatment. Second is true, ex parte decision. Third is not true. No. A complaint is deemed to be resolved when when the complainant agrees that they are fine with the decision taken by the regulated entity, or the complainant has agreed in writing that the resolution that is provided is satisfactory, or they're voluntarily withdrawing the complaint. So this is incorrect. Fourth statement, ombudsman is empowered to interfere. Yes, this is true. Written versions must be provided within 15 days with no provision. No. If the regulated entity provides reason to give more time, then the ombudsman can extend this. So the correct answer will be B and D only. Okay. Which of the following statements are legally and procedurally accurate under the ombudsman scheme? The tenure of the ombudsman and the deputy ombudsman may not exceed 3 years after the appointment, but there is no restriction on reappointment. The ombudsman must hear all the complaints physically at the RBI office. This is not true. Online complaints are also accepted, so B becomes incorrect. C, all physical email hand delivered complaints will be routed through the CRPC. True. Online complaints are required to be submitted at a centralized portal. Yes, which is maintained by RBI. So 1, 3 and 4 is correct. Second statement is incorrect. All right. Let us answer this scenario. A complainant alleges that a regulated entity failed to act on a clearly documented refund request, causing financial loss and undue distress. After attempts at the resolution failed, the Ombudsman, having considered RBI's directions and banking practices, issues an award directing compensation of 15 lakh for the loss and 50,000 for harassment. Which of the following statements best reflect the legal position? So the ombudsman has exceeded his jurisdiction as no more than 10 lakh can be given? No. The maximum compensation can be 20 lakh, or the amount involved in the uh, complaint, whichever is less. The award shall lapse unless the complainant furnishes an acceptance letter. This is true, and it has to be done within 30 days. Third statement is also true, right? Maximum 1 lakh for mental harassment can be given as an extra compensation, and the regulated entity also must comply with the award within 30 days. So, again, the correct answer will be B, 2 and 3. All right, 2 and 3. No, fourth statement will be incorrect. Why? If, let's say, the regulated entity they make an appeal, then this 30 days can be exceeded. All right. Now we come to the MSMED Act, the Micro, Small and Medium Enterprises Act, under which first we have the definition of the MSMEs, which was revised under the Atmanirbhar Bharat package on 13th May 2020. This definition was the first earlier definition based on plant and machinery, equipment. There was also the differentiation between micro enterprises and service enterprises. Then they have been changed. A composite criteria has been given, investment and turnover criteria. Also, on 13th of May 2020, the limit was 1 crore and 5 crore for the micro. For small was 10 crore and 50 crore. But for the medium enterprises, it was what? 20 crore and 100 crore. But then again, a change in the definition was made on 1st 6 2020. According to this definition, the limit of the medium enterprises has been increased. 50 crore is the investment and 250 crore is the turnover. All right. Then other important terms which are given in the act that have been asked by the institute. Appointed day means the day following immediately after the expiry of 15 days from the day of acceptance. So when the goods have been accepted by the buyer, or no complaint has been filed by the buyer regarding the quality of the goods, from that day 15 days, and then the next day, the 16th day, is the appointed day. Day of acceptance means actual delivery and acceptance, or when, let's say, the goods are delivered, the buyer has some issues with the quality standard or any other condition, they will make a complaint, and the day on which the complaint is resolved will be the day of acceptance. Day of deemed acceptance means when no objection is made in writing by the buyer. That is the day of deemed acceptance. All right. Then under the MSMED Act, we also have the National Board for Micro, Small and Medium Enterprises. Head office will be in Delhi, right? It is going to give advices to the central government for the promotion of the MSMEs, and no act or proceeding of the board can be invalid merely on the reason that there was a defect in the vacancy or constitution, there was a defect in the appointment of a person acting as a member, or any irregularity in the procedure of the board, right? Similarly, we have the advisory committee. Again, officers of the central government will be there. They will give advice to the national board, the National Board of Micro, Small and Medium Enterprises. All right. Then there is also these things we have discussed. This is important. Liability of the buyer. So basically, delayed payments to micro and small enterprises will invoke penalties over the buyer. So where the supplier supplies any goods or service or renders any services to the buyer will have to make the payment on or before the date agreed upon between them. And if there is no agreement, then maximum 45 days. All right. If there's no agreement, appointed day is on which the payment has to be made, that is 16th day from the day of acceptance. Otherwise, according to the agreement, but this agreement also cannot exceed 45 days. Then, date from which the rate of interest will be payable. So, next day, when the date of appointment is there or the delay is made after the day of agreement, from the next day, immediately following the date agreed upon, penalty will be paid at three times of the bank rate notified by the RBI. So, starting from the next day. All right. Then there's also the micro small enterprises facilitation council, which is referenced in the case of dispute. All right. Okay. So where there's any amount due to the micro and small enterprises, it is not paid in due time, then a dispute is there and it can be referred to the board. Okay. So these are the provisions of the act. Now, let us answer some questions. Which of the following changes were made to the MSME definition in the Gazette notification on 1st of June 2020? So you need to answer according to the revised definition. The investment limit for the medium enterprises was increased to 50 crores. The turnover limit for the medium enterprises increased to 250 crore. We already know these two statements are correct. So the correct answer will be A. Okay. Which of the following statements accurately reflect the statutory obligations and penalties imposed on the buyers under the relevant provision? A buyer is subject to statutory audit and must disclose in their financials the interest due but unpaid at the year end along with any other future interest. Disclosure is required only for the principal amount, no, even for the interest which is unpaid. A buyer's first time failure to submit the required annual returns will have the penalty up to 1000 rupees. Delayed payments must require disclosure of the interest. True. A buyer who contravenes section 22 is liable to pay a penalty not less than 10,000. Right. So E statement is true and the C statement is not true. Not mandatory up to 1000. If it is the first time failure, up to 1000. Second time failure, from 1000 to 10,000 rupees. So the correct answer is A, D, and E. Okay. Next, we have the SARFAESI Act. About the SARFAESI Act, we have already studied in so much detail. Let us just go through them. The important provision. So it extends to the whole of India, including state of Jammu and Kashmir. Then the money lenders, banks, they can directly enforce the security interest without having recourse to the court. Securitization, reconstruction, recognition of any interest. Then what else is there? The act is applicable to the cases where the security interest for securing the repayment is more than 1 lakh rupees and the amount due is 20% or more of the principal and the interest amount 20% or more. The act is not applicable to any security interest on agricultural land. Creditors other than the secured creditors are not eligible. Also, we discussed about the constitutional validity in the Mardia Chemicals versus Union of India, wherein what was said, if making an appeal to the DRT, first it was required to deposit 75% of the amount. That has been removed. So the section 17 has been removed. The remaining act remains constitutionally valid. All right. Appellate tribunal, we have the DRT and the DRAT. The DRT will be composed of the presiding officer, DRAT will be composed of the chairperson. Then there's the board. When we are referring to a board, it is the SEBI. All right. SARSAI is the central registry to which every charge is to be registered, modified, or satisfied. The SARSAI will also maintain a register of all of these transactions. There's the DRT, Presently, there are 39 DRTs and 5 DRATs. EDRT is also there. All right. Financial assistance, financial asset, not performing asset. Originator is the creditor. Obliger is the borrower. Right? Property can mean the property which has been securitized. Securitization means acquisition of the financial asset by the ARC. So the bank, they can themselves take the SARFAESI course, securitize the asset on their own, or they can transfer the pool of asset or a single asset to the ARC. The ARC will, under the trusts created, issue the security receipts. The whole process that is there. Okay, what is security interest? We already know the right title or interest in the secured asset. Security receipt is what? It is the tradable instrument which is issued by the ARC to any qualified buyer. Sponsor means any person who promotes the ARC. All right. Then the ARC should be registered with the RBI before commencing with the operation. Also, they should have the owned funds at the time of registration, not less than rupees 2 crore or whatever is mandated by RBI, right? RBI, when giving the certificate, will maintain the things that the company will have to comply with. If the company fails to comply with the directions, or they fail to maintain accounts in accordance with the requirement, or they fail to submit any books for inspection, or they fail to obtain prior approval of RBI in the change of management or registered office, the RBI can cancel their registration. Okay, all right. Then they can also make an appeal, right? Within 30 days from the date of communication of the cancellation order, the ARC can make an appeal to the central government, right? Then what else? The ARC will acquire the financial asset of the banking company. They can issue debenture, bond, or they can make the immediate payment. Then they will issue security receipts to the qualified buyers. However, when the bank or the financial institution decides that the financial asset will now be acquired by the ARC, a notice may be given about the acquisition to the obliger. But giving of such notice is what? It is optional, it is not compulsory. In case the obliger is a company, then also it is optional. However, if they give a notice to the obliger, then they have to give the notice to the ROC as well. All right. Then the ARC is going to raise funds for the acquisition of an asset by the issue of security receipts, in which only the QIBs or the institutional investors will be allowed to invest, not the individual investors, right? What else? If in the event of non-realization of the financial assets, the QIBs of the ARC not holding less than 75% of the total value of the security receipts, they can meet and they can decide whatever action that the ARC will take, and the ARC will be bound by that decision. All right. Okay. Measures of asset reconstruction, proper management of the business, sale or lease of a part or whole of the business, rescheduling of the payment of debts, enforcement of security interest, settlement of dues payable by the borrower, taking possession, selling of the possession. All of these are there. RBI has the powers to issue directions, to give the registration, to carry out audits and inspection, also to cancel the registration of ARC. Enforcement of security interest. How can the ARC enforce the security interest in the favor without the intervention of the court? This power is given to the bank, right? So either they can themselves sell those NPAs, any account which is classified as NPA, facility wise securities can be provided, or they can transfer it to the ARC. Already we have discussed this. When, let's say, a secured creditor is required to take possession or control of the secured asset, they can take help from the Chief Metropolitan Magistrate or the DM. All right, again, they will have to make a request and they can seek the help when any when the, let's say, management of the business of the borrower is taken by the secured creditor. No compensation to the directors for the loss of office is paid. Although, let's say, any person is aggrieved by any of the measures taken by the secured creditor, they can make an application against the measures. This application can be made to the DRT. Within how many days? Within 45 days from the day on which such measures are taken. If they are aggrieved, then they can also take the second appeal to the DRAT. All right. So appeal to the appellate authority within 30 days can be made. Right. So this is the enforcement of security interests. SARFAESI we have already discussed. Any cancellation, any registration of charge, everything has to be made to the SARFAESI. Right. If any person after, let's say, the ARC has received the assets and then the borrower, they're trying to dispose of the property, they're trying to transfer the property to any other person, they will be liable for penalty. This will be considered as a criminal offense. All right. Also, where the ARC fails to comply with any of the directions, they can also be deemed guilty and penalty will be imposed on such person. Right. So these are the power. So this power of adjudicating authority to impose penalty or appeals, all of these are given to the DRT and the DRATs. Right. So the appellate authority, the Central Board of Reserve Bank may designate such officers who will exercise the power of the appellate authority. They will have the power to pass such orders as it deems fit. Right. Then any of these cases will be dealt by the Metropolitan Magistrate or the Judicial Magistrate of the first class only. All right. Now, let's say when we are applying to a court in a suit for sale of mortgaged property, the court can pass only the final decree, the preliminary decree, and the final decree simultaneously. First, the preliminary decree and then the final decree. First, the preliminary decree and the final decree after 30 days. Already, the answer is here. The court will first give a preliminary decree and then the final decree. So, two orders are passed by the court. Which of the following correctly capture the updated penalty and adjudication process under the SARFAESI post the 2016 amendment? RBI may directly impose penalties up to 5 lakhs for the non-compliance. So this was pre 2016 regime. No longer it is valid. Then the second statement says the adjudicating authority may impose a penalty of 1 crore or twice the quantifiable amount. Yes, this is according to the amendment made. A reasonable opportunity of being heard must be given by the adjudicating authority. Again, this is true. If the penalty is not paid within 30 days, the adjudicating authority must immediately initiate criminal proceedings. No, both the parties will be given a chance to be heard. So the correct answer should be A, 2 and 3 only. All right. What are the powers given to the SARFAESI Act? To the central government under the SARFAESI Act? The central government by notification can exclude certain provisions from applying to specified classes of the financial institutions. The central government, does it have this power? Yes. Every draft notification must be placed. Any change that has to be made in any act, the same rule is followed. For 30 days in both the houses of the parliament, it should be placed. So this is also true. Once the parliament has disapproved, then the central government may enforce it. No. And the notifications must be laid. So 1, 2, and 4. 1, 2, and 4 should be correct. So that is all about the SARFAESI Act. Next, we have the RDB Act, the Recovery of Debts and Bankruptcy Act. So this is where the cases are there from the individual borrowers or even corporate borrowers. All right, the constitutional validity of the act was challenged. If you remember the whole story, it was challenged by the Delhi High Court Bar Association before the High Court, the Delhi High Court, and the Delhi High Court decided that the law is unconstitutional. It is void and hit by Article 14. The High Court said that the civil courts have the right to decide, and if any special courts are created, then the High Court will be deprived of their jurisdiction. But the government contended that to run the financial system of the nation correctly, it is important that their cases should be resolved as soon as possible. So we need to create special courts like DRT and DRAT. So they took this case to the Supreme Court. And the Supreme Court took the decision in favor of the Union of India and declared the statute to be constitutionally valid. All right. However, there was also the question of applicability to the cooperative banks. It was decided that the DRT mechanism is not applicable to the dues of the cooperative banks because they already have a good mechanism for their resolution. So, this was the constitutional validity part. All right. Now, certain things which are defined: appellate tribunal, DRAT, appointed day, the day on which a tribunal is created in a particular area. From that day onwards, the civil courts will have no right of jurisdiction. Bank can be any bank, nationalized banks. Chairperson is the chairperson of the appellate tribunal. We will also study the qualifications of the appellate tribunal chairperson. So every DRT is presided over by the presiding officer. What is the qualification of the presiding officer? They should have been or they should be qualified to be appointed as a district judge. They will hold a term of office for 5 years or until they attain the age of 65 years. Similarly, for the chairperson of the appellate tribunal, they should have been qualified to be a judge of the High Court. Apart from that, that person has been a member of the Indian Legal Services for 3 years, or they have held the office of the presiding officer for at least 3 years. They will hold the office for a term of 5 years or until they attain the age of 70 years. So remember the difference between the qualifications. All right. Any person shall not be qualified for the appointment of the chairperson. These things are given. Then from the date of establishing of the tribunal, that is the appointed day, no other court will have authority, any jurisdiction to deal with the cases where the claims of the banks and financial institutions are rupees 20 lakh and above. All right. And any person who is aggrieved by the order passed by the DRT can take it to the DRAT. Right. So we have discussed the qualifications, we have discussed the jurisdiction, procedure of the tribunal. Any application can be sent to the tribunal by the bank or the financial institution within the local limits of whose jurisdiction the branch or office of the bank is there. All right. Or any of the defendants are living or the cause of action actually arises, the DRT will take the case. Right? So the application will be filed before the tribunal in the manner as may be prescribed by the tribunal. Then the tribunal will issue summons to the defendant to show cause within 30 days of the service as to why the relief paid should not be granted. Here the complainant is the bank, defendant is the borrower. Direct the defendant to disclose the particulars of the properties, restrain the defendant from dealing or disposing of the property, transferring the ownership to any other person. So the defendant has to now within 30 days from the receipt of the service of summons they will have to present a written statement of his defense. They can file a claim for set off or a counter claim. Okay, so 30 days time is given and a written statement should be made. When the defendant makes a disclosure of the property or the assets after the summons have been made, or if let's say they have not complied with any of the order, then the presiding officer, they will direct the release, they will give their order accordingly. All right. Then if at any stage of the proceeding on an application made by the applicant along with the particulars of the property to be attached for the recovery of the debt, this application can also be made. It will be estimated, it will be attached. If let's say the proceedings are going on but there is no result of the proceeding, then the attachment order can be passed by the tribunal of whole or part of the property, right? On satisfaction that the provisions are not working. All right. So, what can the tribunal do? The tribunal can appoint a receiver of the property, remove any person from the custody of the property, give possession, custody, or management of the property to a receiver, confer powers to any person, also appoint a commissioner. Okay. The cases can also be transferred from one tribunal to another if necessary. The DRT can order that any fact may be proved by affidavit, and once the affidavit is removed it can also be cross examined. Then if we are talking about appeal to the appellate tribunal, any person who is aggrieved by the order passed by the DRT or deemed to have been passed by the DRT can prefer an appeal to the appellate tribunal, right? But if the decision was taken by the DRT with the consent of the parties, then the appeal cannot be made. When the appellate tribunal receives the appeal, they will give a chance to be heard to both the parties, and then they will give the decision. They can confirm or modify or set aside the order passed by the DRT as soon as possible. Then also, when you are making an appeal to the DRT, no deposit is required. But when a defendant against whom the DRT has passed the recovery order, they want to make an appeal to the DRAT. There they will have to deposit 50% of the amount which is determined by the tribunal. All right. And there's also a limitation. That means that the application must normally be filed by the bank within 3 years from the cause of the action. All right. So apart from this, nothing else is there. Okay. All right. Next, let us move on to the IBC code, the Insolvency and Bankruptcy Code of 2016. This is also a very important act. Basically, the SARFAESI Act and the RDB Act, they were not working very fine, and the secured creditors, they were facing many problems when enforcing their recovery rights. So the IBC code was enacted by the government, and it has also been amended quite a few times. First, let us recall the definitions. Insolvency means when the individual or the organization is unable to meet its outstanding financial debt towards the lender and it becomes due. Insolvency can be resolved by changing the repayment plan or by writing off a part of the debt, so by restructuring. Bankruptcy, on the other hand, means that now the person has declared themselves as insolvent and they have gone to the court. So now the court is responsible to liquidate the personal property of the insolvent and hand it out to the creditors. And it also provides a fresh lease of life to the insolvent. Then there are the financial creditors. to whom any financial debt is owed, money borrowed, any amount raised by acceptance, any amount raised pursuant to any note purchase facility, right? Operational debt, on the other hand, a claim in respect of the provisions of goods or services, including employment of a debt, that is the operational debt. Corporate debtor means a corporate person who owes a debt to any other creditor, right? Then the act is going to cover any company under the company law or created under by any special act. Every LLP will also be covered. Any other body incorporated under the law by the central government or any other government. Personal guarantors to the corporate debtors, partnership firms, proprietorship firms, and individuals. All of these will be covered under the IBC code. Then there are four pillars of the IBC. First, we have the insolvency professionals, basically who are going to assist in the completion of insolvency resolution, liquidation, and the bankruptcy proceedings. They are the regulated persons. Regulated persons means that they are a member, they have been registered with the IBBI as a insolvency professional, and they have also passed the limited insolvency examination. Okay, so these are the things that need to be followed. Then second pillar is the information utilities. Information utilities, as the name suggests, they would have the responsibility to collect, collate, authenticate, and disseminate the valid financial information. They will also maintain the electronic database on the lenders, on the terms of lending. So, whenever any dispute arises, to eliminate those disputes and any delay. Okay. Third are the adjudicating authorities. Adjudicating authorities will be four. The NCLT. NCLT will have the responsibility of hearing the cases of the corporate persons, NCLTs, where the cases relating to insolvency of the corporate persons are there. Also, the limited liability entities, these cases will be held by the NCLT. The appellate authority will be NCLAT. Second is the DRT, which also exists. DRT will be for the insolvency proceedings related to the individuals and the partnership firms with unlimited liability. And the appellate authority will be DRAT. So they will hear the cases. An appeal can be preferred on the orders of the NCLT to the NCLAT within 30 days or extended 15 days. Also, the orders of the NCLAT are appealable within 45 days before the Supreme Court also, but only on the question of law, right? And then the fourth pillar is the IBBI, the Insolvency and Bankruptcy Board of India. The board has regulatory oversight over the insolvency professionals, agencies, as well as the information utilities. The insolvency resolution can be triggered at the first instance of default, and the process will be completed within the stipulated time period. Basically, the IBC has the main objective to allow the creditors to access the viability of the debtor, agree upon a plan of its revival or the speedy liquidation. So, all of these things will be supervised by the IBBI. All right. Then, what is the insolvency resolution process if the default is above 1 crore rupees? Earlier, this was 1 lakh. It has been increased to 1 crore rupees. Then the code proposes two independent stages. First stage, the insolvency resolution proposal will be there, during which the financial creditors will assess whether the debtor's business is viable to continue or not. They will try to rescue and resurrect the company. Second will be liquidation. Second stage is liquidation. That is, if this IRP fails, Then the financial creditors can decide to wind down and distribute the assets of the debtor. So this is the CIRP, the Corporate Insolvency Resolution Process, which is initiated by the financial creditor, the operational creditor, or the corporate debtor itself. Okay, so we'll be discussing basically about the CIRP by the financial creditor. Okay, so initiation of the CIRP by the financial creditor basically means to whom the financial debt is owed. So the financial creditor alone or with other financial creditors can apply for the initiation of the CIRP against the corporate debtor before the adjudicating authority, NCLT or DRT. Then this application against the corporate debtor can be filed or it should be filed jointly by not less than 100 of the creditors in the same class. All right, it should not be filed by 100, less than 100 of the creditors in the same class, or if there are not 100 creditors, then not less than 10%. These provisions are important, so make sure that you remember them. If let's say the creditors are allottees under the real estate project, then the application for initiating the insolvency resolution plan shall be filed jointly by not less than 100 of the allottees in the same real estate project, or 10%, whatever the case may be. All right. Then the financial creditor will record the default that has occurred within, then the adjudicating authority within 14 days of the receipt of the application will ascertain that yes, a default has occurred. So if they're satisfied that the default has occurred and there's no disciplinary proceedings pending against the proposed resolution professional, they will appoint them. Then the proposed resolution professional will give their consent. Okay, then the CIRP will commence and the procedure will be followed. The CIRP can also be suspended. It was suspended during the COVID-19 pandemic. It can be suspended if an application is made to the courts. However, there are certain persons who are not entitled to make the application, like a corporate debtor who is already undergoing a insolvency resolution plan, a financial creditor who is undergoing the pre-packaged insolvency resolution plan, a corporate debtor that have in the preceding 12 months already completed another plan, right? A corporate debtor who have violated the terms of the resolution or against whom the liquidation order has been made by the court. They cannot make the application. Next, what is the time limit for completion of the insolvency resolution plan? Basically, it should be completed within a period of 180 days. All right, so the resolution professional will file an application to extend the period, but it should be passed, this resolution should be passed at a meeting of the committee of creditors by a vote of 66%. Then only it will be extended, otherwise not. Then the adjudicating authority can also declare a moratorium. They can cause a public announcement of the initiation of the plan, and they can appoint an interim resolution professional. So the interim resolution professional will be appointed by the adjudicating authority. All right. Then if we are talking about the resolution professional, the insolvency resolution professional should be appointed by the committee of the creditors, right? So what will happen? What is the procedure? When an application for the corporate insolvency resolution process is made by the financial creditor, then the resolution professional, they will also give their consent. If no disciplinary proceeding is pending against them, this application will be accepted. And if no proposal has been made, then the adjudicating authority will take reference to the IBBI for the recommendation of the insolvency professional who will act as the interim resolution professional. All right. Then regarding the committee of creditors, the the interim resolution professional will, after the collation of all the claims received against the corporate debtor, they are going to form the committee of creditors. All right, the committee of creditors will comprise of all the financial creditors of the corporate debtor. They will have the right to be represented, they have the right to be voting, right? If, however, they are a related party of the corporate debtor, then they will not have these rights. Okay, then um we have already discussed when any party is a financial creditor as well as the operational creditor, they will be considered to be the financial creditor to the extent of the financial debts that are owed to them. They will not be excluded from the committee of the creditors. All right. Then, when the operational creditor has assigned or legally transferred any operational debt to a financial creditor, the assignee will be considered as an operational creditor to the extent of the assignment. These things are there. Now, in the first meeting, when the committee of creditors is formed by the interim resolution professional, the first meeting will be held within 7 days from the constitution of the committee. The committee in the first meeting, by a majority vote of not less than 66%, right? A majority vote of not less than 66% will resolve to appoint the same interim resolution professional as the resolution professional or any other person. But both of their consent is important. Okay, so where the committee of creditors, they want to continue the interim resolution professional subject to a written consent, they will make the application, or they can also make the application to replace the interim with a new person, again with the consent. They will give this application to the adjudicating authority. The adjudicating authority will forward the name of the resolution professional to the IBBI for its confirmation, and then when the confirmation is made, that person can be appointed. If, however, the board does not confirm the name of the proposed resolution professional within 10 days, then the adjudicating authority will direct the interim resolution professional to continue until the time the confirmation is done by the board. Okay. So this is about the corporate insolvency resolution process. If the resolution process fails, it does not work, or it is contravened by the financial debtor, the corporate debtor, then we will proceed to the liquidation. Liquidation means enforcing, realizing, settling, compromising, dealing with the security interest, and applying the proceeds to recover the debts due, or relinquishing the rights on these assets to the liquidation trust. All right, so now the secured creditor, it is important that they provide these rights to the liquidation authority if they want to recover the debts. All right, so failure to submit the resolution plan to the NCLT, rejection for non-compliance if the decision is taken by the creditors committee, or contravention of the resolution by the debtor. So during this liquidation, no other suit or proceeding will be instituted against the corporate debtor except through the liquidator that has been appointed. The resolution professional will act as the liquidator unless they are replaced. The liquidator shall form an estate of all the assets of the corporate debtor, which is known as the liquidation estate. The secured creditor will relinquish its security interest to the liquidation asset. If they relinquish their security interest, then they will receive the first priority. Otherwise, in the shortfall, they will not be paid. Okay. Assets will be distributed by the liquidator in the manner of priorities, which is the waterfall arrangement. All the sums due to the workman or the employee from the provident fund, the pension fund, gratuity fund will be considered as priority. All right. And finally, upon the assets of corporate debtor being completely liquidated and the liquidator making an application, the NCLT shall pass an order of dissolving the corporate debtor, winding up the corporate debtor. Okay, so this is the process that is followed in the liquidation. We already know the order of priority of payment in the liquidation, which is known as the waterfall mechanism. So first, the payment will be made towards the insolvency resolution cost and liquidation cost. Then the workman dues will be paid, those 24 months before the commencement of the liquidation. All the debts to the secured creditor who have relinquished their security interest to the liquidation estate, wages and unpaid dues to the employees, financial debt to the unsecured creditors, crown debts, that is the government dues, remaining debts, preference shareholders, and the equity shareholders or partners. All right. Voluntary liquidation of the corporate person can also be done when they themselves apply to the code. So this is the IBC code, very important. That is why we have dealt it in detail. All right. Okay, now we are left with the small acts in our module C. We have the Bankers Books Evidence Act. Basically, the banks they maintain accounts and other details in ledgers, registers, and when any claim of the bank is required to be established or proved, it was very difficult to provide it in original. So it was decided that the extracts and the statements of the accounts can be produced. For this, the Bankers Books Evidence Act was enacted. Right. So it extends to the whole of India. It covers all the banks. Bankers books includes the ledgers, day books, cash books, account books, any other records. Right. Certified copy means if it is maintained in the written form, a copy of the entry, it will be a true copy of the entry. If it is maintained in the electronic form, then the printouts of the data, or if it is maintained in the mechanical form, again printout of the entry or any other form. There are certain conditions that are to be followed to consider that printout to be a certified copy. A certificate by the principal accountant, right? A certificate by the principal accountant or the manager to the effect that it is a printout of the entry, it is a true entry, and a certificate by the person in charge of the computer system. So it will contain a brief description of the computer system. Like the safeguards have been adopted to maintain the integrity of the computer system, safeguards to prevent and detect the unauthorized change of data, safeguards to retrieve data that is lost due to any systematic failure, the manner in which the data is transferred from the system to the removable media. All of these things are followed. Okay. In addition to these, a further certificate is required from the person in charge of the computer system that the computer system is operated properly to their knowledge. Then the mode of proof in certain entries, otherwise specifically that the banker's books are itself disputed, the original documents should not be compelled. Also, the officers should not be compelled to act as a witness in the court. Inspection of the books by the order of the court or the judge can be done. That any party will be at liberty to inspect and take copies of the entrance entries in the banker's books for any purpose for the proceeding. All right. So this is the regarding the Bankers Books Evidence Act. Okay, so we have a few questions. In a court, in a civil suit, which of the following statements accurately capture the evidentiary protocol regarding the production and inspection of the banker's books when the bank is not a party? So, a bank officer is legally compellable to produce the original banker's books in every case. Is that true? No, right? It is not true. Then a certified if certified copies of entries are produced, no bank officer can be summoned. True. Parties to the suit may apply to inspect the original entries, but the court may allow this either with or without. This is also true. And a bank may object to the production of the certified copies. Again, so the correct answer will be 2, 3, and 4. Yes. Next question. Which of the following are true regarding the cost and evidentiary burdens in proceedings involving the banker's books as per the Act? So, the Delhi High Court held that the production of the original documents should not be insisted upon unless the documents themselves are disputed. The cost of applications made under the Act lie at the discretion of the court. Orders for the cost passed under Section 7 may be executed by the court that originally passed the order. A certified copy of the bank entry will lose its evidentiary admissibility unless it is supported by a oral testimony from the bank official. We have already covered all of these statements. First statement is true, second is true. However, this order can be executed by any court even though it was not originally given by them, and oral testimony of the bank official is not required. So the correct answer will be A, 1 and 2. Okay. Next is the Legal Services Authorities Act, which basically talks about the organization, jurisdiction of the Lok Adalat. So, Lok Adalats can be organized by the state authority, district authority, Supreme Court Legal Services Committee, or the High Court Legal Services Committee, or even the Taluk Legal Services Committee at the places as and when required. The Lok Adalat will consist of the serving or retired judicial officers, any other person specified by the particular authority that is setting up the Lok Adalat. The experience and the qualifications will also be specified by the particular authority. Okay. Jurisdiction of the Lok Adalat, the jurisdiction to determine and arrive at a compromise or settlement to the parties involved in a dispute. Only where the cases where a compromise or settlement is possible, not any criminal cases. Okay, so also a dispute should not be the dispute can be a pending case between the civil court, it is a transferred one, or directly it is sent to the Lok Adalat. Offences which are compoundable under any law that cannot be brought within the purview of the Lok Adalat. And the monetary ceiling is also there. Only those cases where the amount involved is 20 lakh rupees, not more than that. Okay, then the cases where the disputes the parties they agree to refer the dispute to the Lok Adalat where the application is made by any other court or even the banks, right? The Lok Adalat will try to arrive at a compromise or settlement between the parties, but that compromise or settlement will be awarded only if both the parties agree. It cannot be forced upon any party. Also, if the compromise could not be arrived, the parties they have the right, they can take it to a civil court. If it was a transferred case, the civil court will take back the case. They will start from the point from which the case was transferred. Fresh proceedings are not required. Okay. What else? And if let's say it was a transferred case and the Lok Adalat was able to arrive at a compromise, then the fees will be returned back to the parties. All right. So these are the important points regarding the Lok Adalat's jurisdiction. Okay. Which of the following powers are exercisable by the Lok Adalat and the permanent Lok Adalat? Requestioning the public records from any government office, administering oaths and examining the witnesses on oath. Both of them are true. Framing charges, no. Cognizable criminal cases, compoundable criminal cases under any law cannot be taken by the Lok Adalat. And they can receive evidence on affidavits. So, 1, 2, and 4. All right. Now consider the following with respect to the jurisdiction and limits of the Lok Adalats. Matters pending before a court or matters not yet instituted but within the jurisdiction may be brought before a Lok Adalat. Yes, either pending cases or any cases directly can be brought. Compoundable offences under the prevailing law may be referred to and settled by the Lok Adalat. The compoundable cases under any law. The offences which are compoundable cannot be brought within the purview of the Lok Adalat. Alright, so this is incorrect. Civil disputes up to a prescribed monetary ceiling can be settled. This is true. Monetary ceiling is 20 lakh rupees. Lok Adalats have the power to adjudicate and issue binding decisions even without the consent of the parties. No, the consent of the parties is required. So only 1 and 3 is correct. Option is not there. Let us say option B is 1 and 3. Okay. Option B is 1 and 3. The correct answer will be 1 and 3. Next, we have the Consumer Protection Act. Basically, the consumers who are the final consumers of any good or any services, they are protected against any unfair trade practices. All right, so consumer who is buying the goods for consideration that has been paid, and they're not going to resell the goods for any commercial purpose. They're going to either use those goods for consumption or for their own employment reasons. Like if a person is purchasing cotton to create clothes that they will use for themselves, that is consumer. Okay, so commercial disputes will not be taken here. Then consumers have the right to be informed about the quantity, quality, purity, standard, and price of the goods. They have the right to be assured access to the variety of goods that are being offered by the sellers. They have the right to be heard and to be assured that the consumer's interests will receive due consideration. They also have the right to seek addressal and the right to consumer awareness. If any of these rights are taken away by the supplier, then it is known as an unfair trade practice. Unfair contract means a contract which will cause significant change in the rights of the consumer. Unfair trade practice means the supply of goods which will adopt any unfair method or deceptive practice causing harm to the consumer. So, an unfair trade practice where the supplier falsely represent that the goods are of a particular standard or of a particular quality, they're representing that they're rebuilt any good which is not actually a new one, it is being represented as a new one. Represents that the goods have any sponsorship, approval, or performance. Represents that the sellers or the suppliers they have any sponsorship, they're making any false or misleading representation. All of these are the unfair trade practices against which the consumers can seek redressal. Now there are certain authorities which are set up under the act. We have the Central, State and District Consumer Protection Council. The State Consumer Protection Council will be established by the state and it will hear the cases of a certain jurisdiction. All right, it will be composed. Wait a second. The State Consumer Protection Council will compose of the minister in charge of the consumer affairs of the state, other official or non-official members. The Central Protection Council will consist of the central officer, the minister in charge of the affairs at the central level, and the District Consumer Protection Council will also be appointed by the state government in every district of the state. All right. There is also the jurisdiction part, which is important, which has been defined that the cases. So the commissions have been created apart from the protection councils. The protection councils basically will have the right to ensure that no party, no supplier is causing any harm to the people in the particular area, in the state or the district or at the central level. Then we have the District, State, and National Consumer Disputes Redressal Commission. This will also be formed by the state government or the national government or by the state government in the each of the districts, right? So, what will be the jurisdiction of each of these commissions? The district commission is going to hear those cases where the consumer has paid a value not exceeding 50 lakh rupees. So the district commission will hear cases less than 50 lakh rupees consideration. The State Consumer Dispute Redressal Commission is going to hear the cases where the consideration is between 50 lakhs to 2 crore rupees. And the National Consumer Dispute Redressal Commission is going to hear the cases exceeding 2 crore. So state will have 50 lakhs to 2 crore jurisdiction, and the National Commission will have more than 2 crores jurisdiction. All right, so wherever the consumer has paid this amount and they're facing a dispute, the redressal will be done by the respective authority. All right, apart from it, apart from the commissions, what else do we have? We have the Central Consumer Protection Authority. Central Consumer Protection Authority will consist of the Chief Commissioner and other officers as appointed by the central government. There will be an investigation wing. They will try to protect, promote, and enforce the rights of the consumers. They will prevent any unfair trade practices, ensure that no false or misleading advertisement is being made, or any person is not undertaking part in the unfair trade practices. So, all of these commissions, councils, and authorities have been created. So, councils are there at the central, state, and district level. They will have the responsibility for the promotion and protection of the consumer rights as per the particular area. Then, at the national level, we have the Central Consumer Protection Authority, which will have the investigation wing. The investigation wing will have the responsibility to conduct inquiry or investigation under the act, and it will be directed by the central authority. The central authority will protect, promote, and enforce the rights of the consumers. Then we will have the Consumer Disputes Redressal Commission at the district level, which will hear the cases where the consideration paid by the consumer is less than 50 lakh rupees. We will also have the Consumer Dispute Redressal Commission at the state level, that is going to hear the disputes or complaints that is 50 lakh rupees to 2 crore rupees. And at the national level, at the central level, it is going to hear the disputes where the consideration paid by the consumer is more than 2 crore rupees. All right, then they will send the cases to the authority, it will conduct the investigation. The finality of orders and limitation period. Every order of the district commission or the state commission or the national commission will be final. No appeal can be made. However, the district commission, there are certain appealable powers. All right. So let's say any person is aggrieved by a decision taken by the councils. Then they can make the appeal, any decision taken by the councils, they can make an appeal to the commissions. All right. Okay, these things we have already studied. There's also the consumer mediation cell, which will consist of the impaneled mediators. They will deal the cases that are brought to them, established by the central government, right? There will be a selection committee who is going to select the members that are going to hear the cases that are referred regarding the consumer disputes. Okay. Now let us answer some questions. Consider the following statements regarding the state and the district consumer protection councils. The chairperson of the state council is nominated by the central government. The state council must include not more than 10 additional members nominated by the central government. The district council must meet at least twice a year at a venue chosen by the chairperson within the district. The collector of the district chairs the district council regardless of the nomenclature of the office. So regarding the formation of the councils, statement 1 is incorrect. Obviously, the chairperson of the state council will be nominated by the state government. The state minister in charge of the consumer affairs is the chairperson. It is not a central government nominee. Apart from it, all the other statements are true. What is the constitution of a state commission under the Consumer Protection Act? Person qualified to be a high court judge, to be the president, and two other members, as and one of them should be a woman. Person qualified to be a district court judge, two other members, one of whom is to be a woman. All right. So the constitution of the state commission, it will be a high court judge who will act as the president and two other members, one of whom to be the woman. This question we have already answered. Okay. Next, we have the law of limitation, which basically talks about the time bar period. It talks about if any proceeding is to be initiated, any act is to be done, it is to be done within a stipulated time period. Beyond that, it cannot be stated. Okay, so here the applicant will be the petitioner, defendant will be the person against whom the petition is filed. How do we compute the limitation? Basically, when the period of limitation expires on a day when the court is closed, then on the next day when the court reopens, we are going to compute the limitation period. Any appeal or application other than the execution petition may also be admitted. When we are computing the period of limitation, the day from which such period is to be reckoned will be excluded. The starting day will be excluded. Also, the time required for obtaining a copy of the order will be excluded. Any time to review the application will also be set aside. If, let's say, the defendant has been absent from India or any territory under the administration of the central government, that time period will also be excluded. All right. So, this is regarding the computation of the period of limitation. Certain acts will also give rise to a fresh period of limitation. Let's say where before the expiration of the prescribed period for a suit or application in respect of any property, an acknowledgement of liability in respect of such property has been made in writing. This will give a fresh period of limitation and it will start from the time when the acknowledgement was signed. So if, let's say, the limitation period is has started, but before its end, the defendant, they have acknowledged in writing their liability and they are ready to pay off the liability, a fresh limitation period will start. Again, when the payment on account of the debt is made before the expiration, this will also lead to the fresh period of limitation. All right, so the computation and the fresh period is important. Then we already have discussed the limitation period for all of the provisions, like the different suits, the period of limitation and the time from which the period begins to run. All right, so in maximum cases, if you remember, the table was there, 3 years time period was there, in some cases 12 years, 30 years in the case of foreclosure, 30 days for the appeal, and 90 days appeal to the High Court against the judgment of a lower court. Other than that, all the period is 3 years for the cases. All right. Which of the following is included in the definition of an applicant? A judge, petitioner, witness, or prosecutor. So we discussed in the very beginning, the person who is making the application will be the applicant and it includes a petitioner. All right. What time is excluded when computing the period of limitation for filing a revision or review application? The time taken for the obtaining of a copy, for initial filing, time taken by a court to hear the appeal, time taken by the appellate court to respond. Again, the time taken for obtaining a copy of the order or the award will be excluded. All right. Now we come to the acts of our module B. Let us quickly go through the important provisions of all of these acts. First, we have the Prevention of Money Laundering Act. Prevention of money laundering enacted in 2002 in response to the India's global commitment, including the Vienna Convention to combat money laundering. Money laundering means any person is trying to conceal or they're trying to acquire a property, dispose of a property that is a tainted property. That is money laundering, right? Then PMLA authorizes the authorities to confiscate the property earned from the illegally gained proceeds, appoint the adjudicating authority and appellate tribunal, and reporting entity, which is the bank. If the reporting entity fails to make a report, then how the penalty will be imposed. What is the appellate tribunal? Chairperson, two other members. The chairperson should have been a judge of the Supreme Court or qualified to be a high court. Duration of 5 years or till the age attain the age of 65 years. So basically, the most important point for the for us is the obligations on the banking companies. So they will have to maintain a record of the transactions that are given in the act. Information should be furnished to the authorities in the prescribed manner and time period. The records will be maintained for 5 years from the date of transaction between the client and the reporting entity. They also are required to practice enhanced due diligence while verifying the identity of the client. Okay, so the records that are to be maintained are very important. First, in the records, the information that should be included: what is the nature of the transaction, the amount of the transaction, and the currency in which it was denominated, the date on which the transaction was conducted, and the parties who initiated the transaction and who was the beneficiary. So, all the cash transactions of value more than 10 lakh rupees, all their equivalent in the foreign currency, all series of cash transactions that are integrally connected to each other. It is by the same person, it is to the same beneficiary person, where the individual transaction is below 10 lakhs, but aggregating all those transactions exceeds 10 lakh rupees in a month. Transactions involving receipts of the non-profit organization more than 10 lakh rupees. Cash transactions where forged or counterfeit currency notes are there, and all the suspicious transactions. Then, where the collection of any cross border wire transfers more than 5 lakh rupees, or purchase and sale by the person of immovable property valued at 50 lakh rupees or more. These are the transactions that the banks, the reporting entities, will have to maintain, and accordingly they will also have to report it to the director. So the cash transaction, series of cash transaction, what else, the transactions involving the non-profit organization receipts, transactions of forged or counterfeit currency notes, as well as the cross-border wire transactions. So these transactions, these have to be reported to the director every month by 15th day of the succeeding month. All right, so this is to be not the suspicious transactions. If we are talking about the suspicious transactions, then within 7 days, within next working 7 days, the information is to be provided. Regarding these four, the information is to be made monthly to the director by 15th of the next month. Also, the cross border transactions by 15th of the next month. In case of purchase and sale of immovable property at 50 lakh rupees, this can be done quarterly. So 15th day of the month succeeding the quarter. All right, so we will remember the transactions, the records have to be maintained, and the time period when the furnish information is to be furnished to the director. These transactions will be maintained in hard copy or soft copy as specified by RBI and SEBI. All right. So this is the Prevention of Money Laundering Act. Next, we have the Negotiable Instruments Act. So the Negotiable Instruments Act talks about the bill of exchange, checks, promissory note, all the negotiable instruments. Two most important things are there: Section 143A and Section 148. Section 143A talks about when a competent court, while trying a check dishonor of the offense, and whenever, let's say, check dishonor is made, it is automatically accepted that the dishonor is made. If the drawer of the check pleads not guilty, they will make this application to the competent court, but the court will accept their application only when an interim compensation of 20% of the check amount is paid to the complainant. So this is section 143A. All right. Section 148 talks about if, let's say, the decision is made by the competent court. Now the drawer wants to further make an appeal to the appellate authority against the conviction under section 138. The appellate court may first order the appellant to deposit 20%. Now in the interim compensation of section 143A, 20% of the check amount is to be given depositive. Under section 148, 20% of the award which is passed by the competent court. And this 20% will be in addition to whatever interim compensation is paid. Both of these will be deposited within 60 days of the date of order. If, let's say, the drawer is acquitted, they're found to be not guilty, then the bank will return this compensation to the drawer, and they will also have to pay some interest. All right. Okay. So if we recall the definitions of the negotiable instrument, those contracts between two parties, always in writing, amount should be expressed, the tenor after which it becomes payable, whether it is payable to order or to bearer, it should be always signed by the issuer. So correctly it should be mentioned. All right. There are certain presumptions to the negotiable instruments also, like of consideration as to the date, as to the time of acceptance, time of transfer, as to the holder is a holder in due course. These things will be assumed, these will be presumed to exist in every negotiable instrument unless the contrary is established. Then we have a promissory note, a bill of exchange, and a check. The difference between them we already know. We also have the terms like drawer. Drawer is the maker of the negotiable instrument. The person directed to pay is known as the drawee. All right. Drawee in case of need. If the drawee is unavailable, then which person can be resorted to? That is the drawee in case of need. Acceptor means this is the case of a bill of exchange. After the drawee of the bill has signed his assent upon the bill, they become the acceptor. Acceptor for honor means when the bill of exchange has been protested for non-acceptance. The drawee is not accepting it. Then the person who is going to accept it supra protest for the honor of the drawer or any one of those endorsees. That is the acceptor for honor. and payee means the person to whom the instrument is directed to be paid. So it is the banker's duty to pay the check whenever in due course, after following all the due diligence, they have made the payment. And if any miscalculation or misrepresentation has been there, which was not discernible to the banker is provided protection. This protection is provided under Section 10. But payment in due course means payment in accordance with the apparent tenor and in good faith, where the banker has no reason to believe that any um, change has been made or the person was not entitled for the payment. All right, so in good faith, without negligence, if the payment is done, Section 10 provides protection to the banker. Section 10. Section 85 provides protection to the banker against fraudulent endorsement. All right, fraudulent endorsement. However, conditions have to be fulfilled for protection, like there was no doubt to believe that the apparent tenor was not followed, or the payment is always made in good faith or not. These things will be followed, and then protection will be given. So, here we talk about material alteration. Material alteration means that any change is made in the negotiable instrument, let's say the check, without the approval and consent of the other parties involved, like alteration in the date or name or amount, or when the check is altered into a bearer check. These are material alterations. The bank under Section 89 is provided protection where the alteration is not apparent, where the change is made and it was not discernible to the naked eye, then Section 89 provides them protection. Then there's also the case of holder in due course and holder for value. Holder does not mean physical possession, holder means legal possession. All right, so any person who is entitled in their own name to the possession of the instrument and to receive or recover the amount due thereon means the holder. All right, holder in due course means who for consideration has become the possessor. So the person who was legally entitled to receive the payment has given this instrument to another person in due course for consideration acquired before maturity and no defect exists. Holder for value when, let's say, we are talking about a collecting bank. So that is the holder for value. When a bank, to oblige a customer for any reason, pays the amount of the check drawn on another bank. So the possession of this bank, that is of the collecting bank, that is the holder for value. So the holder for value, or we will say collecting bank, is also provided protection under Section 131 of the Act. Again, it is not possible for them to know about all the signatures of all the endorsees if they are not a customer of the bank. So protection will be provided for them. All right. So these things are there. Already we have discussed everything. Paid within 60 days, extended 30 days. If the drawer is acquitted, found to be not guilty, the court will direct the bank to repay the drawer the amount of interim compensation, the 20% amount, with interest at the bank rate as published by RBI. All right, again within 60 days or 30 days. Section 148, 138 already we have discussed. All right. So this is the Negotiable Instruments Act, how the banks are provided protection. Next, we have the Foreign Exchange Management Act, which has replaced the Foreign Exchange Regulation Act of 1973 to consolidate the foreign exchange resources of the country for proper utilization. Basically, it has authorized the authorized person, any authorized money changer or dealer, offshore banking unit, any other person authorized by under the FEMA to deal in foreign exchange or securities. All right. We have the definition of the capital account and current account transaction. Capital account transaction, any foreign exchange transaction that changes the asset and liabilities of the people involved. Current account, that does not change the asset and liabilities of the people involved. Currency means not only the notes, but postal notes, orders, money orders, checks, drafts, everything. Foreign currency, anything other than Indian currency, right? Foreign exchange means amounts which are payable in foreign currency, drafts, travelers' checks, letters of credit, all of these are included. All right. Person resident in India, we already know the definition, who have resided in India for 182 days. They have not left India for taking up employment outside, carry on a business, or they have some intention to stay outside for an uncertain period. Similarly, any person who comes to India to take up employment, carry on a business, or to remain here for an uncertain day. So, travelers will not be included in the definition of the person resident in India. All right. Also, security is defined. Security defines the shares, stocks, bonds, and debentures. However, it does not include the bills of exchange and promissory notes other than the government promissory notes. So the government promissory notes, they come in the security. Other than the government promissory note will be included in the currency. All right. So basically, RBI has been given powers to appoint the authorized persons, to inspect the authorized persons, that the authorized persons are complying with all the rules and regulations. Another important term is repatriate to India, which means bringing back to India the realized foreign exchange. So basically, the selling of such foreign exchange to an authorized person, holding of the realized amount in an account with an authorized person. This means repatriate to India. So what does the act says? The FEMA Act basically says that no person can deal or transfer any foreign exchange or foreign security to any person not being an authorized person. They cannot make any payment to or for the credit of any other person resident outside in any manner, again without the involvement of the authorized person. They cannot receive otherwise through the authorized person any payment, or they cannot enter into a financial consideration for the or in association with the acquisition or creation of transfer of rights, again without the authorized person. So basically, there is no bar on a person resident outside India to hold, own, transfer, or invest in foreign currency, security, or immovable property situated outside India. Only when the resident in India, they are engaging in the foreign exchange, that should be through the authorized persons. Powers. Contravention, we have already seen, if any person contravenes any provision of the act, they will be liable to a penalty if it is quantifiable or if it is not quantifiable. So if it is quantifiable, then thrice the amount involved if the contravention is quantifiable, or if it is not quantifiable, then up to 2 lakh rupees. And if it is a continuing one, then further penalty for each day that can extend to 5,000 rupees. All right. If they're acquiring any property, then the value of the property also. The government has the right to confiscate the value equivalent in India. Obviously, there's the right to make an appeal also. So, any person who is aggrieved by the decision taken by the authorities, the government, they can make an appeal to the appellate authority, which is constituted, if you remember, not under the FEMA Act, but the appellate tribunal constituted under the Smugglers and Foreign Exchange Manipulators Act. All right. Then we have the Directorate of Enforcement that will have the power of search, seizure, and empowering other officers. Right. Then we have the Payment and Settlement Systems Act of 2007. Again, the designated authority here means RBI. Any company, if they want to start or commence the operation of a payment and settlement system, first they will apply for a registration with RBI. RBI has the right to conduct the scrutiny. They can accept their registration, they can reject their registration. At any point, if they do not comply with the RBI regulations, RBI can also cancel their registration. Okay, so designated authority is RBI, and authorization for the continued operation of an existing payment system. When the act came into force, within 6 months, they have to apply for the authorization, right? Also, RBI can refuse the authorization after conducting proper scrutiny. Scrutiny will be conducted under Section 6, application will be made under Section 5, authorization or refusal will be given under Section 7. Scrutiny under Section 6, RBI should be satisfied that there's actually a need for the proposed payment system. They have the technical standards, the terms and conditions are followed, the procedure that they are following is under the RBI's regulation. When RBI is giving the authorization, they will state the date on which it takes effect, the conditions subject to which the authorization will be enforced, payment of fees, security, everything. RBI can also cancel the registration, and if the registration is cancelled, they can make an appeal against the registration to the against the decision to the central government within 30 days. All right. Also, regarding any change in the payment system. So, before the change may be levied, prior approval of the Reserve Bank is required. Also, not less than 30 days to the system participants to be given before implementing the change. This 30 days restriction can be exceeded if RBI says, or it can be completely removed if it is in the interest of the monetary policy. RBI has the power to access information. They can authorize any person to enter the premises, check the computer system, call for any document. RBI also has powers to issue directions which will be binding on the payment system. Then we have netting and settlement. Next, we have the types of mortgages that we have already covered in the Transfer of Property Act. So the simple mortgage is there without delivering possession, personally liable. The mortgager makes themselves personally liable. And in the conditional sale, the sale is ostensible. If default is there, sale will become absolute. If the payment is done, sale will become void. Usufructuary mortgage, where the payment obligation is recovered from the rent and profit, but banks do not prefer it. Why? Because it will take a very long time and there's no personal covenant. English mortgage, where absolute transfer of the property is there on the condition that it will be reconveyed on the payment. English mortgage is, equitable mortgage or mortgage by deposit of title deeds is there. In Kolkata, Chennai, Mumbai, the property can be located in any of the state, in anywhere in India. They are keeping the document of title which will evidence the ownership of the mortgager over the property. Right? So the mortgage, we will say, will include only the original copies. Only the original titles, copies will be accepted only in exceptional cases if allowed by the court, otherwise not. Then priority of mortgages. Every secured creditor who got the charge registered will have the priority over the unsecured creditors. Between two secured creditors, the one that was executed first will have the priority, right? What else? Limitation period in mortgages is there. For sale of the mortgage property, 12 years. For filing a suit for the foreclosures, it is 30 years. Then copy of the document of title, where it will be acceptable only in exceptional cases. All right, so these are the rights of the lender, of the mortgagee, that are available in the different types of mortgages. So in a simple mortgage, there's no passage of title. Title deed is not kept, delivery or possession is not given, no beneficial interest. but they have the right to cause sale on default, not foreclosure. Mortgage by conditional sale, passage is done, but ostensibly, title deed can also be kept, delivery or possession can also be given. Right to cause sale is not there, but right to cause for the foreclosure is given. Similarly, go through all of these rights that are given to the mortgagee. Next, we have the other types of modes of charges that are there. We have the appropriation, assignment, set off, lien, and so on. So, what is appropriation? Appropriation basically means when the debtor owes several debts to the creditor, many debts are owed, and they are making a payment. So there are three things. There are three sections. Section 59 says where the debtor, they are making an intimation, application of payment where the debt is to be discharged is indicated by the debtor. The creditor will have to follow it. Section 60 says where it is not indicated by the debtor, then the creditor may apply it at its own discretion to any lawful debt actually due, whether it is barred or not barred by the law in force. And section 61, where neither party appropriates, they do not make any appropriation, then the law will work. All right, so the payment shall be applied in discharge of the debts in the order of time. One that was created first will be paid off first. This is the section 59, 60, and 61 under appropriation. Next, we have assignment. Assignment means where the person who is the assigner, they prefer to transfer their rights or benefits to another person, that is the assignee. There can be no transfer of duty, burden, or detriment without the express agreement of the assignee. All right. So the transferee is the person to whom the rights have been transferred. Let's say A owes money to B and he transfers the debt to C. So B then demands the debt from A. This is what? This is an assignment. Right? So there's the assignee's right, which is subject to equity. They will have only the same rights that were there with the assigner. The assignee cannot have better rights. The assignee cannot also have less right than that. Then we have a pledge. Pledge basically means bailment of goods for providing security, as we have already studied in our module D. So the pawner-pawnee relationship is there. Ownership of the property remains with the pawner. It is only subject to the qualified interest which passes on to the pawnee by the bailment, right? This transfer can be actual delivery or it can be a constructed delivery, like handing over the key of the godown in which the goods are kept. By atonement, let's say the warehouse man acknowledges to the pawnee that they're holding the goods on their behalf, handing over the document of title of goods, or when the pawner is actually in possession, they will give an acknowledgement that they're holding it on behalf of the pawnee. All right. Pledge can be created only in the case of existing goods, specified goods that are in possession of the pawner himself. So possession is important. Priority of charge in a pledge, the special interest in the movable property passes on to the pledgee. Who can create a pledge? The owner, mercantile agent, any person who is in possession of the goods. They can also create a pledge. Pawnee will have the right of retainer, the right to claim extraordinary expenses, but they do not have the right to retain the goods for any other debt other than that for which the goods were pledged. They also have the right against third parties. No person can come and claim those goods from the pawnee. All right, so in the case where the pawner defaults, he may sue the pawner upon the debt or promise. He may also retain the pawned goods as collateral. He can sell off the goods after giving the reasonable time. All right, there was a situation whether two notices must be given or not. So let's say if the goods are sold by the pawnee after giving reasonable notice, the pawner is entitled to receive from the surplus and the pawner also has the right to redeem the goods even though the time stipulated for the payment is over. Separate notices are not there. That a sale notice is only an intimation of the proposed sale by the pawnee. It is not necessary that such notice may be proceeded that he is making or not making the sale. All right. Duties of the pawner, duties of the pawnee, advantages of the pledge. All right. Okay. Then hypothecation is there. Hypothecation basically means a mortgage but of the movable property. So without delivery of the possession of the movable property, a security is created, and when the default occurs, then the floating charge is crystallized into the fixed charge. Then the creditor will have the absolute right. So that is hypothecation, right? Hypothecation will be provided only to the respectable customers because it is only equitable without possession. It will be beneficial when the loan is raised against the work in progress. This is the only way of creating a charge. Also, those goods which require constant handling, like any machinery, rice mills, oil expellers. It is also convenient when lending is done against the goods in a shop. All right. Precautions should be taken in the case of hypothecation. Then we have the banker's lien. Lien basically means the banker has the right to retain the possession of the goods and securities owned by the debtor until the debt due from the latter is paid. But these goods or securities should come to the banker's possession in the ordinary course of banking business. So if the customer forgets a packet containing some share certificates, insurance policies, on that the lien cannot be created. Only the normal course of banking business, the lien can be created. All right, so let's say the bank has for safekeeping kept the money, funds, securities of the customer. They can create a lien, they can retain those goods, they can reject to return the goods until the customer pays the debt. And this pledge is a implied pledge. Lien is what? It is a implied pledge. Then we have set off. Set off basically means cancelling out. So the set off is the right of the debtor to take into account a debt owing to him by the creditor when claiming a debt due. In the case of the banker, the right of set off enables him to adjust the debit balance in the customer's account with any balance outstanding to his credit. So the amount that the bank is required to pay to the customer, an amount that he is entitled to receive from the customer, they can set it off. There are certain things that you need to keep in mind. The set off, right of set off will be available under which situation. So let's say the deposit is in the name of single person, loan was taken in the name jointly with others. So will the right of set off be available? Yes. If the deposit was in the name of a partner, loan in the partnership firm, the partners are unlimitedly liable, so it will be available. Deposit single name, loan in the same name available. Proprietor, proprietorship firm available. But if the deposit is in the name of the partnership firm, but the loan was taken by one of the partners, then the bank cannot exercise set off. If the deposit was in the name of the trust, loan in the name of the trustee, not available. Similarly, opposite is also not available. Deposit is in the name of the dividend account of the company. Loan is in the loan account, not available. Deposit is in the name of a minor, but the loan was taken by guardian. The bank cannot set off the claim. And finally, the deposit was in the name of the joint account holder, and the loan was in the name of one of the joint holders. Again, it will not be available. All right, so these are the various areas under which the right will be available to the bank to create a set off. All right, next we have the meaning of a charge. That is the last unit of our Banker's lien we have already discussed. Now we have the meaning of a charge. Charge means what? Charge means where a security interest is created in the name of the creditor, an interest or lien created on the property or assets which are provided as security, right? Charges that require registration in the Companies Act 1957, there was a 1956, there was a list. Only the following charges were required to be registered to be filed with the ROC. But the 2013 Act has said it doesn't matter whether the charge is created within or outside India, on the own property or assets or any of its understate undertakings, tangible, otherwise situated in or outside India, every charge will have to be registered. This is under the Companies Act of 2013. However, there are certain exceptions, like a corporate guarantee does not require registration. Any charge arising due to operation of some specific law where the registration is not required, or a Hyundai, which is a negotiable instrument. Now, charge can be a fixed charge or it can be a floating charge. Fixed charge is known as a specific charge where the charge is created on the specific identified property. The creditor will have the right only on the particular specific property. Floating charge, on the other hand, means specified property is not there. The charge floats over the present and the future property. All right. And until a specific event occurs, it will not be crystallized. Right. There's a benefit of the floating charge. When happening of an event or contingency, it crystallizes as a fixed charge, and then the charge holder, the creditor, will have the right over all of the assets of the property. That is the benefit of a floating charge. So when does the floating charge become fixed or crystallized? When the debtor company ceases to carry on business, they're going into liquidation, so it will be beneficial for the creditor to convert their floating charge into a fixed one, right? So when a floating security upon all the property becomes crystallized, it constitutes a charge upon all the property or assets then belonging to the company, and it will now have a priority over all the other subsequent equitable charges. All right. So, what is the procedure for the registration of charge to the ROC? By filling up the various forms like CSG 1 for debentures, CSG 9 for debentures, that include rectification, modification or charge, satisfaction of charge. Now you need to remember, within 30 days of the charge creation or modification, if the charge is registered, normal fees will be paid. After 30 days, within 60 days, additional fees. After 60 days, within 120 days, again additional fees. Beyond 120 days, the charge cannot be registered. This modification has been made after the ordinance of 2nd November 2018. All right. What will be the effect of registration of charges? It will make the charge holder a secured creditor. What will be the effect of non-registration of charges? They will not have priority in the case of liquidation of the company. Then the various provisions of the Companies Act relating to the registration of the charges. The most important ones are, it is important for the company to get the charge registered. If the company fails, then the charge holder should create the charge, should register the charge with the ROC. All right. Whatever fees that they have to pay, they can recover it from the company. This right is given. Then any modification, satisfaction also needs to be registered. If any company files to the ROC the satisfaction of charges, so the ROC will send a notice to the charge holder to show cause within certain days whether the charge is actually satisfied or not, and then they will register the charge. All right. Done with module B. Now we have the module A. Only the important provisions of these acts we are going to discuss. The Banking Regulation Act and the RBI Act. So this session will go on for, I think, maximum half an hour more. and then we will be done. All right. Okay. So, basic things, the Banking Regulation Act, the Section 5B defines the definition, the business of banking, acceptance of deposit from the public, lending or investment of such deposits. These deposits are withdrawable in nature, accepted from the public, can also be rejected if they do not comply with the KYC or anti-money laundering or any other guidelines. When we are talking about the license which is given under the Section 22 of the Banking Regulation Act, license will be given by RBI. And now the banking company will have to use the name bank, banker, banking as a part of its name. No other company is allowed to do that. Important sections: 5B defines the banking company. Section 22, license for banking. Section 6, the permitted business. Apart from accepting deposits and giving out loans, the banks are also allowed to engage in other activities like bill discounting. They are also allowed for drawing, accepting, advancing money with or without security, realization of any property, guarantee, indemnity. Prohibited business is given in Section 8, that is, direct trading in the goods is not allowed, direct or indirect trading. Section 21 talks about the restrictions on the loans and advances, like to the directors, related persons, the loans and advances cannot be given. Section 35, the powers of RBI to give directions. Section 26, returns have to be claimed on the unclaimed deposits. Section 29, balance sheet. Section 43, CRR. All right. Then, if we are talking about the Reserve Bank of India Act, the important sections, Section 3, 7, 17, 18, these sections are there. RBI Act basically enacted to stabilize the economy, to function as the regulator of the monetary policy. RBI uses various qualitative and quantitative measures to control the inflation, deflation, and other factors. All right. Then, any company, if they want to start the banking business, they will have to apply for a license with RBI under Section 22. If any company wants to open a place of business, they have to also get prior approval from RBI under Section 23. So, without obtaining the prior permission from RBI, no banking company shall open a new place of business. Otherwise, in the same city, town, or village, also no banking company will open a new place of business, or they cannot also not change the place of business without attaining the prior approval of RBI. This obviously does not include the temporary places within 1 month. So a mela, exhibition, or any counter, that is exempted. Then important is the paid up capital and reserve requirement. So the foreign banks, they have to deposit and keep deposited with RBI an amount of 15 lakh rupees. And if it has its place of business in Mumbai or Kolkata, then rupees 20 lakhs. This point is very, very important. All right. Apart from this, they will also be maintaining 20% of the profit for each year in respect of the business that they have transacted through the branches in India. All right. Then, if we are talking about Indian banks, then paid up capital and reserve should not be less than what? If they have the place of business in more than one state, 5 lakh of rupees. And if the place of business is in Bombay or Calcutta, then 10 lakh rupees. If it has all its place of business in one state only, none of which is situated in Bombay or Calcutta, then 1 lakh rupees in respect of its principal place of business plus 10,000 rupees in respect of each of its other places of business in the same district of the head office plus 25,000 out of the district in which the principal place is situated, right? If it has all its places of business in one state and it is in Bombay or Calcutta, then 5 lakh of rupees plus 25,000 any place outside of Bombay and Calcutta. Then this ratio you should remember between the paid up capital, subscribed capital and authorized capital. The subscribed capital of a banking company shall not be less than half of its authorized capital. The paid up capital shall not be less than half of its subscribed capital. All right. And if the capital is increased, this requirement will be complied within a period not exceeding 2 years that is allowed by RBI. Then regarding the voting rights of the shareholders, although there's no specified ceiling except the cap on the 5% paid up, however, certain restriction is there on the voting rights. Holding of shares is not in restriction. Voting rights, there's a restriction. So no person holding shares in the banking company shall, in respect of any shares held by them, exercise the voting rights in excess of 10%. So maximum 10% voting right one single person can have. Then regarding the payment of dividend, if the banking companies want to pay dividends on the shares, they want to declare dividends. First point, it should be made payable out of the current year's profit only, current year's net profit only. Then to declare dividends, they should have the CRAR of at least 9% and the net NPA should be less than 7%. CRAR should be more than 9%. If let's say they do not meet the CRAR norm, not more, it is not more than 9%, minimum 9% is there, and the net NPA is less than 5%, then also they will be eligible to have to declare the dividend. All right. Also, the banking company shall comply with the provisions which prohibits the payment of dividend until all capitalized expenses have been written off, and section 17 which stipulates the transfer of specified portion of profit to the statutory reserve fund. Then RBI also regulates the banking business. So it regulates the banking business by giving some directions on the loans and advances or the interest rate. There are certain restrictions. No banking company shall grant loans or advances on securities of its own share. They cannot enter into agreement for granting loans or advances to or behalf or of the directors. Also, firms in which the director is substantially interested, any company where the director holds a substantial position, like a director, manager, managing agent, loans and advances cannot be given. Now, although the interest rates have been deregulated, still RBI has said that how the banks are going to decide their interest rate. So earlier there was the BPLR system which was introduced in 2003. It fell short of its original objective. Why? Because the banks they could lend below the BPLR also. This was replaced by the base rate system. Base rate will include all the elements of the lending rates which are common across all the categories of buyers. This will increase the transparency. The actual lending rates charged may be transparent and consistent. However, there were also some issues with the base rate, so it was replaced by the MCLR to determine the lending rates. Now, the banks cannot grant any loan below the MCLR except in certain circumstances. What is the difference between MCLR and base rate? MCLR is determined by the cost of funds. Base rate is governed by the average cost of fund. MCLR is set by the banks on the basis of structure and methodology. MCLR is an improved version. It is a risk-based approach. It considers unique factors like the marginal cost of funds instead of the overall cost of fund. It also takes into account the repo rate, which was not there in the base rate, right? Fixed tenor fixed rate loans of tenor above 3 years will be continued to be exempted. What will be included in the MCLR? The marginal cost of funds, the negative carry on account of the CRR, operating costs, as well as the tenor premium. Then the MCLR has also been replaced by the external benchmark base rate. So all the new floating rate personal or retail loans, floating rate loans to the micro and small enterprises, they will be benchmarked to any of the external rating. The rating, which is RBI repo rate, Government of India 3 months treasury bill, Government of India 6 month treasury bill, or any other benchmark as given by FBIL. Banks are also free to offer any other external benchmark. However, under a particular loan category, uniform external benchmark must be adopted. Multiple benchmarks under the same loan category is not allowed. Last, we have the categories of NBFCs, the base layer, middle layer, upper layer, and top layer. So, which NBFCs will be included in the base layer? All the non-deposit taking NBFCs below the asset size of 1000 crore, and NBFCs which are the peer-to-peer lending platform, account aggregator, operative financial holding company, those that are not availing any public funds. Middle layer will consist of all the deposit taking NBFCs irrespective of the asset size, non-deposit taking NBFCs with asset size of more than 1000 crore, and the NBFCs who are the standalone primary dealers, infrastructure debt fund, core investment companies, housing finance companies, and the infrastructure finance companies. These are specifically stated. The upper layer, only those NBFCs that require enhanced regulatory requirement. Doesn't matter what is their asset size. No, doesn't matter what is the function. Whatever function they perform will not be taken into consideration on the basis of their asset size. The top 10 NBFCs on the basis of their asset size will always be included in the upper layer, and the top layer will ideally remain empty only if there's a substantial increase in the potential systematic risk in the NBFCs of the upper layer. Then those NBFCs from the upper layer will be shifted to the top layer. And with this, we have revised all the four modules. Other than this, you need not worry about anything else. Okay. So now let us finally answer some questions from our module A, and then we will end the session. All right. Which of the following are correct about the non-banking assets under Section 9? Banks can hold immovable property up to 7 years. RBI may extend the period by additional 5 years. Banks can acquire the immovable property for speculative purposes. Reporting to SEBI is mandatory for the banking assets. So, fourth statement is absolutely incorrect. We need not report to SEBI, and banks are not allowed to acquire immovable property for the speculative purpose for any reason. So, the correct answer is A, 1 and 2. Then, which of the following are true regarding the capital requirement? Very important question. Indian banks that have branches in more than one state require a minimum requirement capital of 5 lakh rupees. Foreign banks operating in Mumbai must maintain 20 lakh rupees. Indian banks in one state excluding Mumbai or Kolkata requires 10 lakh rupees. All the banks must deposit 20%. So we have studied this 20% of the profit is required by the foreign banks. Other than that, all the three statements are correct. Okay, this we have studied. Then, as per the section 10A, which of the following are applicable regarding the board of directors? At least 51% of the directors must have special knowledge or experience in the specified field. This is true. At least one of the director must be a chartered accountant. No. The directors should represent different interests, including agriculture and rural economy. The various classes are mentioned. The chairman must be appointed directly by the RBI. No, only in exceptional cases. So, 1 and 3. Then, Which of the following are true with reference to the Reserve Bank's regulatory authority over loans and advances? Under the Banking Regulation Act, the RBI may direct a banking company to maintain specific margins on secured lending with reference to the reserves and deposit base. Does RBI have that authority? Yes. Then, under Section 20, a bank may grant a loan to a company in which the director has substantial interest if such company is registered under the Section 25 of the Companies Act. So, where the director has substantial interest, there the bank cannot give loan. Then, selective credit control measures, while aimed at controlling inflationary holding, have been frequently applied to restrict the short term credit structure. Not true. And the RBI's general powers under the Section 35A may be invoked alongside Section 21 to regulate and conditions of advances. So, the correct answer here will be second statement is incorrect and the third statement is also incorrect, right? So 1 and 2 should be correct. All right. Which of the following statements correctly reflect the regulatory framework? Under Section 23, the RBI may refuse permission for relocation of branches even within the same city if it deems the move contrary to the public interest. So RBI has been given discretionary powers. So true. Second, the temporary branch opened for 25 days requires prior approval. No. Within 1 month, if the temporary branch is opened, it does not require prior approval. The RBI's power to revoke the permission is contingent about the bank violating conditions. Is this true? Yes. And a pay office situated in a city different from the registered office does not fall. This is also true. So when we are talking about the place of business, when we are talking about the district, so this fourth statement applies there. So 1 and 3. All right, in accordance with the regulatory framework governing the lending under the external benchmark system, the operating cost component of the spread over the external benchmark may be revised once every 3 years subject to mutual agreement. Although it is true that the operating cost should be reset, but it should be done once in 3 years at the bank's discretion. Borrower's mutual agreement is not required. So this is incorrect. Then banks may revise the credit risk premiums only if there's a material shift in the borrower's credit profile. True. The borrowers who are eligible for prepayment of the penalty without charges must be offered a switchover. Again, true. Then the interest rate resets under the external benchmark must be done once, at least once in 6 months. No, it should be done once in 3 months, not 6 months. So the correct answer is C, 2 and 3. Which of the following statements is inconsistent with the requirements of the Banking Regulation Act? This we have already seen. You can easily answer it. A foreign bank that has branches in Mumbai and Kolkata have to maintain a deposit of 20 lakhs. This is true. The ceiling of 5 lakhs is there on the Indian banking company. The Reserve Bank may recommend a temporary exemption. That is also true. But the third statement, which says that the subscribed capital must always be equal to the authorized capital, no. The correct answer should be that the subscribed capital must be half of the authorized capital. Then a shareholding a shareholder holding 30% of the banking capital cannot exercise more than 10% of the voting rights unless RBI specifies true, right? The maximum right is voting right is 10%. If RBI specifically gives someone more rights, it can be increased to 26% in a phased manner. The title to share in the banking company can be challenged in the court even if the transferee fails to register. No. The bar proceedings against the registered holder will be based on the ownership title, and it should not be the lawful transfer. Then, third statement, without prior approval, a person acting in concert with others cannot acquire shares amounting to 7% of the banking company. True, right? And basically, the limit is 5%, and the statement says 7%. So, this is a restriction. And the statement 4, once RBI registers a transfer of shares in the violation of 5%, it will still allow full voting right? No. This will take away the voting right. So the correct answer will be B, 1 and 3. Last question. In the light of statutory mandates under the Banking Regulation Act, which of the following statements are accurate regarding the periodic returns? A banking company must file a quarterly return on the domestic assets within 1 month from the end of the relevant quarter. Non-scheduled banks must report their CRR position twice a month, referencing alternate Fridays. Failure will invite compounding penalty. All banking companies must submit a monthly return by the end of the following month. Scheduled banks required to furnish demand and time liabilities in Form 1 at intervals. So, here which answers are true? Except for one, all the others are true, right? Why? Because the quarterly return on the assets must be submitted under section 25. The rule 14 talks about what? It talks about the unclaimed deposits. All right. Otherwise, the statement is correct. So the correct answer will be D, 2, 3, and 4. And that is all. With this, we have completed all the four modules. We are done with the revision of all the four modules. Now, do not worry about anything else. Have faith in your preparation. You have practiced all the possible MCQs. You have covered the concept. You have the theoretical knowledge. Don't worry about anything else. Take a good night's sleep. Take good care of your health. Tomorrow, wake up with a fresh mind. If you want to revise any topic that you find tough, do it in the morning. And also try to attempt all the questions because there is no negative marking. Now, attempting all the question does not mean that you will stay stuck on a particular question. No. If you think that a question is very lengthy or you believe that you do not know the answer, leave it. Forget it, move on to the next one. Answer those questions first that are doable, that you are certain that you will get correct. Do them first, then attempt those questions that are a bit tricky, because our aim is to score 50 plus marks. So once you get the 50 plus marks, that will be enough. So I wish you all the best for your exam. You have prepared well, so have faith in your preparation. Do your best with a clear mind, with a composed mind, without any confusion, with full confidence. Go and attempt the exam and do your best. Also, this will not be the end. Even if you are not able to crack, then also this is not the last opportunity. So do not be disheartened. We will always get another opportunity. Our preparation is 100%. Still, if luck is not by our side or the institute gives certain questions which are very difficult, that is not our problem. Okay, so we will have confidence in our preparation, and with confidence, we are going to attempt all the questions in tomorrow's exam. Tomorrow, after your first shift, we will have the exam analysis at 11:30. So please, those who have your exam in the first shift, do attend that session. Others also, because it will be profitable for you. Although the questions are not repeated, but the institute can repeat the topics. So those who have the exam in the first shift, join the session at 11:30. Tell us in the comment section what all topics have been asked, what was the difficulty level of the question. And those who have the exam in the second and third shift, you attend so that you can know this thing. All right, so that is all from my side. I will be ending the session now. I will see you tomorrow after the exam. and I will congratulate you on your success. So let us meet tomorrow. Thank you so much. Good night and take care and all the very best for your exam.